This is Judge Middleton. You got arrested last night for alleged violation of your bond. Also with us here on the feed is Paul Gibson. He is filling in for the public defender. He came on short notice. I saw when I came in this morning that you'd been arrested and Bell got arrested.
Yes, sir.
Let's start from the beginning. You're charged in file number 252254FY with assault with a dangerous weapon. It's alleged that you tried to assault or did assault your partner, Bell Ghost, with a shovel. You got arrested and the bond was set in the amount of $15,000 cash or surety, which you posted. One of the conditions of your bond was that you were not to have any contact with Bell. According to the bond violation report, the police executed a search warrant at this house because of zoning issues, 700 Hoffman Street. Is that the big old house with the old Jacobs house?
No, Your Honor, it's not. And she had just showed up, like literally right when that had started happening. She actually would testify for me on my behalf. She said that she had just showed up.
Well, who lives at that house?
It's not a house, it's a property, and there's tents and
all right, so yeah, people have started to camp out back there.
yeah.
At any rate, you guys were a mess. I don't want to go too much into it, but they found you in a camper in not good circumstances, drugs, and they arrested you for violating your bond condition. They arrested Bell for a violation of Judge Stutzman's order. She also has a warrant out for her from Battle Creek. So now you're not supposed to have any contact with each other, and you're both in the jail. You and Bell are not in the same cell, are you?
Yeah, we are.
Oh, you're in the same cell?
Yes, sir.
Oh boy. The matter is set for a pre-exam conference with Rhonda Ives. For December 9th. There was some sort of a camper there?
Yes, sir.
Is that where you were staying?
Yes, sir.
Is it hooked up to electricity or anything?
No, sir.
All right. Well, the clear condition was you weren't supposed to have any contact. And we were both there in the same camper, and the allegations were not the best. I wish the hearing were sooner. You're essentially homeless, and so is she. Now she's in jail, and you're in jail, and you're in the same cell. How crazy is that? You're not supposed to have any contact with each other. Mr. Gibson, do you have any input on this?
I guess not right now. Is she it sounds like she's asking, like she's disputing that she violated the bond condition.
Well, like I said, Belle said she would testify for me that she had just showed up, like, right when the officers had showed up. She wasn't there previously to that.
My original thought was I was just gonna leave you in jail until December 9th. You seem pretty good this morning, but I don't want a housing issue for the jail, and I got both of you in the same cell. You weren't, the place is not good. You're a trespasser on there. Who owns this camper?
I do.
Well, you got to get it off of there. Have you got someplace to put it?
Yeah. Yeah, I could take it to Jeff Brown's.
Well, he's not doing well, but he did tell me that you're welcome at his place.
Yeah.
I asked him about that. He said, no, she's welcome to be here.
Yeah.
This is a strange circumstance. You're charged with an assault with a shovel. And from the report, Bell didn't want to cooperate with it in the first place. That's not the problem. The problem is methamphetamine or opioids. I'm going to find bond violation and give you 1 day credit 1 day. I don't want you and Bell sitting there in the same cell. You're going to get out of jail. I also don't want you to forfeit your $15,000 cash or surety bond. You can't have contact with each other. She's going to be in jail for a while. Judge Stutzman's got a hold on her, and so does Calhoun County. But I'm not accomplishing much if I got you guys in the same cell. You didn't really do anything, but you got to get your stuff out of there. Also, if I leave you in jail, they're going to haul all your stuff out of there and take it to the dump or something. You need to get out, get that property out of there. You're going to lose all of it.
Yes, sir.
All right, Ms. Ghost, your next hearing is set for December 9th. Bell, are you acceptable with me making a finding that Mandy, that you had contact with Bell in violation of the condition of your bond?
I'm sorry, what was that?
Are you acceptable with me making a finding that you violated your bond by being in that camper with Bell?
I mean, yeah, sure, I guess, yeah.
All right, and I guess the offer was I'm gonna let you out of jail, but I don't want you sitting there in the same cell, and I don't want an administrative headache for the jail to figure out what to do with both of you. So I'm letting you out. I want you to go back there, get your stuff, and get out of there before the city takes it to the dump.
Yes, sir.
All right. Good luck to you.
Can I just add one thing, Your Honor?
Yeah.
I also know that Mandy Allen is scheduled for a status conference in circuit court on Monday, December 8th at 9:30. So she should make a note of that.
They didn't cancel it? They added to it.
Yeah.
All right, you got that, Mandy?
Yes, sir.
All right, you got one hearing Monday and one hearing Tuesday.
Thank you.
Those pants are kind of droopy. They need better lady pants for the jail. All right, you're good to go.
Thank you.
Put those green jumpsuits on.
Better lady pants. Okay, wherever you are right now, I want you to pause what you're doing and just do this with me. Just repeat after me. Ready? Shovels and meth in a tent. Oh my. 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 You're welcome. That's now stuck in your head for the rest of the day. Congratulations. I told you we were going to have fun today. As far as them being in the exact same cell, that is that little-known, seldom-used Michigan Mutual Compact Gladiator rule, where they basically just set them up for a cage match, and, you know, whoever wins, wins. All right.
Case, Mr. Boyd. Robert Thomas Boyd, 25B82557. Calling the Bay City Attorney, please.
Ladies and gentlemen, this is
Township
Horderman.
Attorney.
Enjoy.
Morning, John.
How you doing, Mr. Boyd?
Pretty good.
Your name?
Robert Thomas Boyd.
Okay, so I'll give you a lawyer if you want one. This,
Thank you.
you know your right to a lawyer?
Yes.
You're here for a review hearing. Please tell me you did something with the property.
Oh, yes, sir. I got a big trailer full of stuff out of there.
Did you?
Yeah. A big trailer. 6.5 feet high, 8 feet long, wide, and 8 feet long.
Did you get everything out of there?
Not everything.
No.
He's supposed to bring me another trailer when he dumps out.
I know, but did they take the whatever debris you put in the trailer and remove it?
The guy's taking it out there today.
Good morning, Your Honor. Caitlin Floyd, Potter, Brownstown Township.
So I said, do I dare call this case? What have they done? Go ahead.
Sure. Ordinance Enforcement Officer Rob Harris went by the property yesterday. He advised that the dumpster was full. The garage, trailers, boat, cars, junk, and debris were still evident from the street. He did go into Township Hall and obtained a demolition permit application. However, he's never filed that, nor has he gotten a demolition permit.
Well, I don't need it, Your Honor, until I get ready to demolish it. I'm pulling everything out of that garage, the cabinets and all that stuff. So when I demolish it, it'll come down easy. So I didn't know if there was a time limit on the demolition permit. Is it? You don't know? No, she don't know either. He's supposed to bring me back another trailer today.
You gotta move a little quicker here.
Well, that's a lot of work.
We've been talking about this. You were issued citations quite some time ago.
Yeah.
And this citation was issued in April. This is November. How many notices did they send prior to that again? How far back does this whole issue go?
The property itself is, the ordinance violations have occurred since 2001.
Okay. So last I looked at the calendar, it's 25, right? I wish it was 2001, but it's not. Please, I don't want to have to send you to jail again.
I don't want to go. I got too much work to do on that.
I know, but you gotta move faster. Please?
Getting help would help a lot, but it's hard to do.
And then, Your Honor, I did, last time we were here, a Good Samaritan knocked on my door and advised that they were there because they wanted to help Mr. Boyd. My understanding, she received his phone number from one of our hearings. She tried to make contact with him multiple times, left multiple voice messages, and he never returned her call. She is interested in finding help. He just needs to connect with her.
With
Her name's Adrian. She left you a couple voicemails.
she did?
She did.
She wants to help me?
She does.
She's gonna let that heavy stuff?
She has a whole bunch of people that want to help you to stay out of jail.
See,
I didn't get them.
Mr. Boyd, listen to me. I have felt awful sending you to jail, but I have a job to do here, and I'm going to do my job. I don't know what else to tell you, sir. You gotta move. You gotta get this stuff out of there once and for all, for your safety too. All right, here's what I'm doing. I mean, I don't think she would tell the prosecutor she called if she didn't call. Probation is extended. I'm extending your probation. Probation's extended until, but this doesn't mean you have this long to do this. Do you understand?
Yes, I do.
To July 30, to July 30 of 26. No probation fees. Lisa, please give me another review hearing date sometime in early July.
I'm looking. Hang on one second.
Take your time. I'm going to set another
July 1st at 9 o'clock.
at 9 o'clock. Now I'm going to give you another review hearing date to come back in front of me, but I want all this stuff going. Listen to your voicemail. Call the lady if she's willing to, or your sons. I don't care who you get, sir.
If Mr. Boyd wants to
Yeah.
be in the conference room, I'd be happy to give him.
Sure.
Okay.
Now listen, I don't care who does it. You know, ultimately it's your responsibility, but I can't give you much more time. And I know you're going to start telling me the weather, but you should have done it when I told you to do this. Lisa, give me something the second or third week of July or January, please.
January 14th at 8:30.
That's your new review hearing date. So the other one, the July date, is to dismiss the case if you're compliant.
Okay.
This is going to be another review hearing date, January 14th. You got to get going. You got to call that guy, have him empty that, give you another dumps, whatever you got to do.
I understand. I would just like to reiterate that I think our biggest concern is still the major spill.
Of course it
Right.
is. It needs to be. Mr. Boyd, come on, man. You're such a likable guy, but you're killing me. You know that? You're going to make me do something again that I don't want to do. I already had to do something twice that I didn't want to do. Come on, please. Don't do this. Get this stuff, get that all taken care of by January, and we all can all go on. I'll buy you lunch. You and I and the prosecutor and the building official go out. I'll buy lunch. Take care of it, please. January 14th. Thank you. Have a good day.
Thanks.
Mr. Randall Pittman, good morning. Mr. Pittman, you've been accused of one count of, the first appearance sheet says intent or threat to do violence. I'm assuming it's an assault allegation. Once I read the complaint, that's the assault statute they're using. So you've been accused of one count of misdemeanor assault. And I've been advised through a text this morning, a text to Mr. Mitchell and myself from Mr. McDaniel, that you do not want an attorney appointed to represent you for first appearance purposes. Is that correct?
That's correct, Your Honor.
Okay. So I don't know if I've ever had that at first appearance. Do I have to go through the same analysis for first appearance purposes as I would for representation?
Judge, I don't think
otherwise?
I've ever seen that either.
But I think it is each stage of the proceeding that you have to inform him of his pro se rights.
Okay. So you have the right to an attorney. That's the best thing to do, especially if you don't have any legal background or legal training. But if
I
you
do,
want to
Your Honor.
represent
Can I
yourself,
explain to
you're going to have to let me talk. That's one thing attorneys
Okay.
do is they let the judge talk and then you'll get a chance. We take turns. That's kind of how it goes. So I've got to ask you some questions to see if, you know, about your educational background and your desire to represent yourself. And I've got to stress to you the importance of why that may be a bad idea. So tell me about your educational background, Mr. Pittman.
I went to Cottondale High School
Okay. Any college?
initially, and then I got transferred over to Gracefield High School.
Any college?
I have a bachelor's degree. My brother and I received scholarships at Marshall University, football scholarships.
Okay.
I played
Mr.
football.
Pittman, what is your bachelor's degree
baseball.
in some kind of legal studies or something totally different?
My degree is in business administration.
Okay.
And,
Mr. Pittman,
but
did you have any postgraduate work? Did you work towards a master's or anything?
Well, I've been working undercover for the state of California for about 20 years as an attorney general.
Mr. Pittman, as an attorney general?
And that's a sad point for Jackson County because they didn't know that. But I had to reveal that now because I'm in court.
Mr. Pittman, have you ever been to law school?
I've been going up and up. I'm sorry.
Have you ever been to law school?
I'm sorry.
I need you to listen to my questions, Mr. Pittman. I'm asking you specific questions for a specific reason. Have you ever been to law school?
No, I've never been to law school.
Okay, so here's what you got to understand. Mr. McDaniel has been to law school and accredited law school. He's graduated from that law school, and then after that, he took and passed the Florida bar. And after that, he's been practicing law, Mr. McDaniel, in excess of 20 years. Is that right?
Correct.
So here's the thing. This is what I heard a judge explain it to me one time. He explained it to a defendant, and I was in the courtroom. You're about to enter a process, and the way the judge described it, you're about to have surgery. And what you're saying is that even though there's a doctor, a surgeon here next to me who's willing to do the surgery, and that's his job, I don't want to do that. I want to go ahead and do surgery on myself. That's essentially the analogy that I'm using for you representing yourself. In other words, it's a bad idea. Knowing that, you still want to waive your right to an attorney and represent yourself for first appearance purposes.
Your Honor, I promise you, I'm the best attorney in the nation. I promise you that. So
do
I'm
you want
willing
to represent yourself for first appearance purposes?
Yes, I do. Yes, I do.
All right. So do you want to be heard on the issue of probable cause?
Yes, I do.
Go ahead, please.
First of all, Your Honor, this was really a bad decision by the sheriff's department. Enfield, he's the one who he tells these guys to do this every time to me and my mom. He's already told me, I don't care where you take your mom, but you need to get her out of Jackson County. So that's why all this stuff keeps happening. It's called Enfield. And honestly, Judge Garcia, she's a good and fair judge, but she is being controlled by Enfield. That's why all this stuff is going on.
Your Honor, we're going to.
All right. So, Mr. Pittman, that's nothing to do with probable cause. That's just you rambling. So I'm not going to listen to any more of that. Mr. Pittman, before you elected not to use him, Mr. McDaniel sent a text this morning to Mr. Mitchell and myself questioning whether there was probable cause in your case. And his question was that it appears to be a conditional threat, and conditional threats typically cannot qualify as assault because the assault statute says the threat must be imminent. That's the key word in this particular analysis. Mr. Mitchell, any position on, or Mr. Gill, either one of you, on whether or not this meets the basis for probable cause for assault?
Judge, it does appear to be a conditional type of analysis. We would ask for 24 hours to amend. There could be facts that were not put in the probable cause affidavit to establish a charge for assault.
Okay, thank you, Mr. Gill. So the complaint says that you allegedly went to where those two people were at, and that may be considered an overt act, which may have a basis or a part of the analysis to determine whether or not there's assault or another crime. So what I'm going to do is I'm going to determine there's no probable cause for assault. But based upon your criminal history, as well as the recent mental health history that the record reflects,
I have no criminal history,
in the other case,
I have zero criminal history. I have zero criminal history.
You do have criminal history. You've been arrested within the last few months for a case involving your mother, correct?
They were all dropped. All those charges have been dropped. Okay. Did you not hear?
Fair enough. Fair enough. They were dismissed. Yeah. You were arrested, but not dismissed. They're still part of your history. They're just not convictions. I'm going to hold you for 24 hours. I'm going to see you tomorrow morning. If they haven't amended the complaint to include probable cause, then I have to release you. That's the law. It's very clear. If they have amended the complaint, then what's going to happen is I will see if the amended complaint includes probable cause for a crime. If it does, I'll set you an appropriate bond or consider other release options. So I will see you in the morning.
You're not going to give me bond today?
You're not getting a bond today because there's no probable cause for a crime. Now, if you want to waive the argument of no probable cause, since you're representing yourself, and agree that there's probable cause or stipulate that you're not contesting that, then I can set you a bond today. Otherwise, I can't set you a bond.
Yes, I'll do that. I need a bond today.
So you want to stipulate only for first appearance purposes that there's. Okay, you want to stipulate for first appearance purposes. Well, your mom's going to be in jail. And you're
No,
going
my
to
mom
have
is-
to contact with your mom. I'm fixing to do a no contact order once I find probable
Oh my
cause
God.
based upon the history.
You gotta be kidding me.
Absolutely
My
going to
mom-
do no contact. That is absolutely going to happen. You're going to have no contact
my
with your mother
God.
because I think you're a danger to her. So my question for you is, do you want to waive any objection to probable cause so that I can set you a bond, or you want me to see you tomorrow and see if they can establish probable cause?
Yes, I want the bond.
Okay. Mr. Gill, you'd like to be heard on the bond.
Judge, we'd just be asking for a reasonable bond, and we would be asking for no contact with Willie Ruth Pittman.
Your bond's $5,000 cash or surety with a condition, no contact with your mother. To me, that is an absolute necessity to ensure her well-being. You have the right to use the phone and post the bond, sir. If you post the bond, you'll be released. Any questions, Mr. Pittman? Court
No,
date,
Your Honor.
January 5th court date. If you give him that notice, please, that would be at 9 a.m. You'll get his phone in just a few minutes, sir, okay? Have a good day.
All right, our next one is also Mr. Diego's, and it's People versus Miranda Bosack. This is file 25-14144 FH. We are here today for, it looks like, a plea in this. All right, do we have Miss Bosack here? Oh, she's in jail in Zoom. All right. Oh, I'm sorry. Miss Carey is here on behalf of the people. She's the Wexford County prosecutor. Mr. Diegos joins us today via Zoom, and Miss Bosack joins us today from the jail via Zoom. Ms. Bosack, are you able to see and hear us?
Yes.
Thank you. All right, we're here today for a plea. Ms. Carey, why don't you go ahead and tell me what the plea is?
My understanding is defendant will be guilty as charged.
Is that correct, Mr. Diegos?
It is, Your Honor. I'm also hoping that Ms. Carey would confirm that the prosecutor's office would not object 7411 if the court finds it appropriate at the time of sentencing.
Sure. Ms. Carey? All right. Ms. Bosack, would you please raise your right hand? Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You may lower your hand. Ms. Bosack, I'm told today that you're going to enter a plea of guilty as charged. Now, we're going to go over this and have it make sense. Before I do, Ms. Carey, do you know, is she eligible for 7411? I don't want there to be anything illusory.
I believe she is. I don't believe she has any record.
Okay, thank you. Ms. Bosack, do you have any criminal convictions of any kind in your past?
I have 2 driving with no insurance and 1 improper registration because it had overlapped.
All right, thank you. All right, Ms. Bosack, also back on November 10th of this year, were you on probation or parole?
No.
Thank you. Bosack, you are currently charged with a single count. That count is possession of the controlled substance methamphetamine. Now, that is a felony punishable by up to 10 years and or up to $15,000. I'm told that you're going to plead guilty to that offense. Now, you might wonder, well, what's the benefit? I'm going to talk about that in just a moment. But before I do, I need to tell you that if you enter a plea of guilty and I accept that plea, you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. Ms. Bosack, do you understand those rights?
I do.
And even more importantly, do you understand that if you plead guilty and I accept that plea, you will be forever waiving those rights as it applies to this particular case?
Yes, Your Honor.
Furthermore, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing an application for leave to appeal, not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record, or that the plea was not of your own free choice. Ms. Bosack, are you entering the plea of your own free choice?
I haven't been able to speak to my lawyer, so it's been a minute.
Okay. Well, we're going to place you into a breakout room right now and allow you that opportunity. But before I do, let me go over just a few more things so you can speak to him about them. In Michigan, when it comes to sentencing and someone's convicted of a felony, there are what's called the Michigan Sentencing Guidelines. And they, while not mandatory, do provide to the court some guidance as to what the minimum end for your sentence would be. While I told you the maximum punishment is up to 10 years, based upon what you have told me, you would probably score, I estimate, this is not a promise, but I estimate you would be scoring approximately 0 to 6 or 0 to 3 months, which means that would be an intermediate sanction cell. And because you've never been on probation, or at least, have you ever been on probation?
No, Your Honor.
Because you've never been on probation and you haven't violated probation, there's probably no reasonable grounds that I could use to give you jail. Now, we've also talked about this other part of the pretrial agreement. Now, this one is a little tricky, but I want to explain it to you. It's an agreement that you've reached with the prosecutor, and it's about sentencing. It's something called 7411. Now, that number, 7411, is just a number of a section of law. And it says that if you are eligible, meaning you have never been convicted of a drug crime, I can place you on a delay of sentence. That could be up to 3 years. And if you complete that delay successfully without violating your terms or conditions of probation, the charge would be dismissed. Now, when we talk about a pretrial agreement with the defendant and the prosecution, I want you to think of 3 different shapes. The first one is just a line. It's a solid line between you and the prosecutor where you reach an agreement. And that's called a Killebrew agreement. Hold on, I got it. We're not giving one. I'm telling her what the differences are. Killebrew agreement, which is not being done here, would be that if I do not agree with the sentence and did not give you 7411, you would have the right to withdraw that plea. That's not being done here. The second shape is like a triangle. That's where I would agree today to place you on 7411. I don't do Cobb's agreement. That's called a Cobb's agreement. I don't do Cobb's agreements because I don't know anything about you other than what you told me today. I could come back here for court and we could find out that you've been on a killing spree around the world and have got aliases and you're wanted for assassinations. I don't know. Just I'm being silly for a reason. We're not doing a Cobb's agreement either. So instead, the last shape is like a dotted line between you and the prosecutor. And it just means that she's going to make a recommendation at sentencing that I place you on 7411.
I am not going to recommend that.
Oh, I thought you said, no, you would object.
Right.
Sorry, she's not going to object. Different. So now we've got nothing. We've got no agreement. That's a fourth shape, which is no shape. It doesn't mean that she's going to recommend it. She just is not going to object to it. So I just want you to understand that. Now, by the way, my likelihood of placing people on 74, no, hold on, that's the wrong way to say it. Statistically, if a person is eligible, I almost always put them on 7411. Ms. Carey, could you just ask before I let them take a break and do a conference? Can you tell me, is there any co-defendant in this case?
Yes, there is.
Is that the person we had in here earlier today? I just saw the long list of witnesses.
No, he is actually set for preliminary exam today in district court, or tomorrow, I mean.
All right, so also what I would expect in Mr. Nagos, after he speaks with her, he might ask me to release her on bond with terms or conditions, which I might want to do generally because I want to see if she's going to be compliant on bond and see how she does. Do you have any other issues there? Like, do I have to do would I have to add a no contact order or something else? Because this looks like it says GPS tether with house arrest. That kind of would lead me to believe that there's something more to it than make that.
There's a lot more to it, and
Uh-huh.
people would oppose a release right now.
Okay.
And there are some things that I frankly don't want to
Talk about.
All
right, thank you. All right, so you've heard a little bit of talk there, Ms. Bozak. Before I take a plea, before I continue, also, and Ms. Carey, because it sounds like maybe there's not a lot of communication, and Mr. Carnes may have been the one handling it. Is there any other term or agreement like required testimony or anything like that?
No, this
Okay.
is my case. I've been handling it. There is no.
Oh, I'm sorry.
she
All
is-
right. That was the other file. I'm sorry. Thank you.
Right, yeah, no.
All right, good enough. All right, Ms. Bozak, my clerk here, or our clerk here, is gonna put you and Mr. Nagos into a private breakout room. And we'll wait until he tells us that you come back. All right, thank you very much. We're in a temporary recess.
Okie dokie, here's another place we haven't gone in a while. Let's go to El Paso, Texas, and jail magistrate court. Let's not, because they just took that offline. All right, be that way, people. Let's go back to Judge McNally then. Let's do that.
All right, so you're gonna plead as charged, correct? To the charge failure to yield, responsible or not responsible?
I'm sorry, what did you say?
Responsible or not responsible to failure to yield?
The responsible.
I'll accept the plea 195. How much do you have today?
I was trying to see if I think did, 30 days to pay.
You work?
Yes,
Where do you work?
AAA life.
How about if I have you pay 50 per week? Can you do that? Or not?
Yes.
I'll tell you what, you pay 50 per week and I'll start this beginning December the 1st, okay? If you ever need more time, just call the court. We'll go on Zoom and I'll be glad to give you an extension, all right? Thank you. Good luck.
Well, he's between contestants. Wahoo, by the way, thank you for the gifted membership a few minutes ago. I very much appreciate that.
Pretty Honor, good morning. Courtroom against the 11-day Thomas Smith, stating himself for sentencing, I believe.
Your name, ma'am? So she just fired her lawyer. He withdrew. She didn't want to represent her.
Judge, she's asking for a 2-week determination.
She's asked me that before and I'm gonna do it, man, but this is it, okay? Last adjournment, adjourn 2 weeks. Lisa, what day we gonna?
Do you want it on a prosecutor day?
There was no accident. I don't really need it on a prosecutor day, to tell you the truth.
Okay, December 8th at 8:30.
Okay, December the 8th at 8:30. So I just want you to know I've adjourned this from October 29th to November 12th, to November 24th, December 8th. No more adjournments, okay?
Okay.
All right, have a nice Thanksgiving. We'll see you here on December the 8th. Thank you.
Thank you.
Thank you, Mr.
I'm telling you. Jamie Ferguson. 25T646810. Defendant failed to appear before Judge and Senate. What's your name, sir?
It's 10:45.
Oh, okay. Okay. How you been doing?
Good, Judge, how are you?
Yeah.
Ready for Thanksgiving?
Yeah. I just.
Just show up?
Yeah.
Literally.
Yeah.
You good, Tom?
Yeah, yes, all set. Thank you.
Are we all set, or are you?
Yeah, I got nothing for everything.
Day or what? It should be there with.
Yeah. Yeah, usually it was
Happy Thanksgiving.
Have your Thanksgiving. All right, have a good one. All right, we'll see you.
Are you, so this is it? You're taking off? You're done?
The boss tells me.
Okay, have a great Thanksgiving, Drew. Take care.
See you.
All right, let's go back to Judge Elmore. It looks like they're continuing where they left off.
Okay, Ms. Bozak, I had told you what the charge was. I had told you what your rights were. I told you how by pleading guilty, you'd be waiving those certain rights. I asked if there had been any other promises, threats, or inducements, which I don't believe there were. Are you entering the plea of your own free choice today, Ms. Bozak?
Yes, Your Honor.
All right, thank you. Now, when it comes to the sentencing, when I talked a little bit about it and tried to give you an idea of how it would work, the question I have for you though right now is, has anyone promised you or asserted to you exactly what the sentence would be?
Did what?
That's all right. If I didn't say it clearly enough, I apologize. Has anyone made any promise to you as to exactly what the sentence would be in this case? All right. Now, any discussion, whether it's about guidelines like what I discussed earlier or in your conversations with Mr. Niegos, those are strictly estimates and guesses and trying to help you understand how sentencing works. Do you understand that?
Yes, Your Honor.
Do you still wish to enter the plea of guilty as we discussed earlier?
Yes, I do, Your Honor.
As to the single count, how do you plead?
Plead guilty.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. So, turning your attention back to the date of October 10th of 2025, out in Herring Township, here in Westford County. What happened, Ms. Bozak?
I was in possession of methamphetamine.
Where were you at the time, or how did you get caught with it?
There was a search warrant issued at my residence.
All right. And was that residence out in Herring Township?
Yes, Your Honor.
And was some methamphetamine found there in your residence?
Yes, Your Honor.
Now, was there anyone else residing with you at that residence?
Yes, there were other people that resided at that residence.
All right. So the reason why I asked that question is because I need to ask a little bit more about how you possessed this methamphetamine. So where was the methamphetamine that you possessed to which you're pleading guilty to? Where was it found?
In my camper, Your Honor.
In your camper. Okay. And did you know that it was in that camper?
Yes, I did, Your Honor.
And did you have the right to possess and or control the methamphetamine that was found on that date in that camper? Oh, I'm sorry. Let me go back and ask it. So to be able to establish possession, either you owned it or you had it in your possession, which means you also had the right to control it. Did you have it within your possession, whether right on you or in the camper, which you had control over?
Yes, Your Honor.
All right, thank you. In your mind, did you have any lawful right to possess that controlled substance, methamphetamine?
No, Your Honor.
And again, you knew that it was methamphetamine.
Yes, Your Honor.
Do you know how much it was? How much it
No,
weighed?
No, Your Honor.
All right, so when I ask this question about possession, because I know that there are things out there that often get charged like residue cases. What was this methamphetamine in?
It was in a baggie, Your Honor.
And so if you were to hold that baggie up, could you actually see it?
Yes, Your Honor.
All right, thank you. That just tells me that it wasn't like a residue that you couldn't see, so you actually had knowledge that it was there. Thank you. Ms. Carey, do you believe she's provided a factual basis?
I do.
Are you aware of any other promises, threats, inducements?
I'm not.
And do you believe the court's compliance with Control 6.302?
Yes, sir.
Mr. Niegos, do you agree with all three of those?
I do, Judge. Thank you.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the offense. Therefore, she is found guilty of count 1. Ms. Bozak, we will be back here for sentencing, and that's typically in about 4 to 5 weeks. It depends upon the holiday schedules of all those that are involved. Between now and then, an agent from the Michigan Department of Corrections, which is also known as a probation or parole office, must prepare a pre-sentence investigation report. This report will describe the pretrial agreement, describe the facts of the case, include information about you that you will provide to them. It will also include a scoring of the guidelines, which again are not mandatory, and it will include a recommendation as to the sentence, which is also not mandatory. The preparation of this report requires 3 steps that involve you. Number 1, you will receive a packet at the jail. You'll open it up, follow the instructions, complete all the information to the best that you can, and then turn it back in. The second is you'll be subject to an interview with an agent from the Department of Corrections office, and you have the right to have your counsel present at the time of the interview. And third, prior to coming back to court, you and your attorney will meet to go over the contents of that report, as each side has the right to appear before the court and ask for corrections, make objections to the contents of the report, as we must make sure that it is complete and accurate before the court uses it to establish a sentence. Do you understand, Ms. Bozak?
I do, Your Honor.
Thank you. Ms. Carey, anything further on behalf of the people?
No, thank you.
Mr. Nagos, anything further on behalf of the defendant?
Yes, Your Honor, briefly, I'm not sure if the court would hear me on bond or if Ms. Carey would waive notice.
Hold on. I'm willing to hear it. However, I turn to Ms. Carey. Ms. Carey, do you waive notice?
Well, I'm going to object to it, and typically I would waive notice, and I don't want to be difficult, but in this particular case with
I don't need to know the
so
facts.
much going on, I'm not going to waive notice.
So we'll have Mr. Nagos, if you choose to file a motion to have the court reassess it, please do so. But according to the court rules, specifically court rule 2.119, there must be notice. So I will wait to see what happens. All right. Thank you very much.
Yes, Your Honor. Thank you.
That's on the record maybe a week or so ago for potential resolution. I met with counsel in chambers. They informed me as to what the terms of the pretrial agreement are that they anticipate today. Ms. House, why don't you go ahead and tell me the terms, please?
Your Honor, the defendant is currently charged with 1 count of criminal sexual conduct 2nd degree pursuant to MCL 750.520 C2B. That is a crime that has a maximum penalty of up to 15 years in prison, requires lifetime sex offender registration 4 times per year, and also requires lifetime electronic monitoring upon release from prison. As the court is aware, we had reached a plea agreement between counsel that we had presented to the court that the court was not comfortable with. But just for the record, that plea agreement was that the defendant was going to give a factual basis to the CSD 2nd charge. And then we were asking that the court enter a conviction for assault with intent to commit penetration, which carries a 10-year maximum penalty. We had reached with that a plea agreement that the defendant would be sentenced to 38 months to 10 years in prison on that prior plea agreement. The court expressed clear concern with doing a plea agreement of that nature where someone's admitting to facts of an offense that is not the offense that the conviction enters for. The court made clear that they would not accept that plea agreement. The court did make clear that they would accept a plea agreement to an attempted CSD 2nd with that same minimum guideline. And so I want to make that clear because the minimum guideline of 38 months in prison, the maximum would then be 5 years or 60 months in prison. That is within the allowable guideline that a court can sentence to up to 2/3 of the maximum penalty. But I do want to be clear that 38 months is outside the minimum guideline range for attempted CSD 2nd. So as I have scored the guidelines, if the defendant had been convicted of straight CSC second at trial, his guidelines would have been 36 to 71 months as a minimum. For an attempted CSC second, I score his guidelines as 7 to 23 months as a minimum. So I want to be clear that as part of this plea agreement, we are now offering that he can plead guilty to attempted CSC second, but the sentence agreement for the minimum remains the same, which is 38 months in prison with a maximum of 5 years or 60 months. And that we are all agreeing right now that we recognize that 38 months is above that minimum and that the court has good reason to accept this plea, but also to exceed those guidelines, and that the defendant is agreeing to that at this point and is not going to be objecting later by saying, well, that was outside the scope or above the scope of the scored minimum guidelines. I also want to be clear for this plea agreement. I had said that if he had been convicted at trial of CSC second, he would be subject to lifetime electronic monitoring. A significant benefit that he gets from the sentence is not only the reduction of his maximum from 15 years to 5 years, but also that there is no lifetime electronic monitoring for attempted CSC second, but the sex offender registration will remain the same. He will register for the rest of his life 4 times a year as a sex offender based on this agreement. So it's my understanding he'll be pleading guilty today to attempted CSC second with that agreement that he serves 38 to 60 months in prison, with the understanding that that is above the scored minimum guidelines, and with the understanding that he will register as a sex offender quarterly for the rest of his life. And in exchange for that, the people will dismiss count 1, the CSC second charge.
All right, thank you very much. Mr. Champion, is that a complete and accurate statement of the trial agreement?
It is, Your Honor, and my client's aware of it. Again, I would emphasize that he would not be required to lifetime electronic monitoring.
All right, thank you very much. All right, Mr. Birch, have you heard what the attorneys have described to me today as the pretrial agreement in this case?
Yes, sir.
And is that how you wish to resolve it, sir? Yes, sir. To the best you can, please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. All right, Mr. Birch, I'm going to go over the terms of this agreement with you in just a moment. Again, we're not arguing any further, but I'm just saying, yep, I do recall our conversation here on the record a week or 2 ago. I also went back and continued to do other research, spoke to several other judges who shared a lot of my concern, and some of the other cases that I had read that talked about interpreting the court rule that we talked about, which was court rule 6.302. A lot of those cases actually were where somebody was appealing wanted to withdraw the plea. The court stood by the plea because when it was entered and then accepted by the court, it was based upon the agreement of the parties. So a little bit, somewhat similar or dissimilar situation, but I stood by Judge Viviano's dissent. Now, in this particular case, we're going to talk about this agreement here right now. Currently, you are charged on a piece of paper called the felony information. That charges you with a single count. That single count is criminal sexual conduct in the 2nd degree upon a person under the age of 13, where the defendant, you, were 17 years of age or older. An act of criminal sexual conduct in the 2nd degree is an act of sexual contact. In other words, touching certain parts of a body under or over clothing. Now that is a felony punishable by up to 15 years. And as you heard Ms. House cover, lifetime electronic monitoring upon parole, and mandatory AIDS and STD testing, DNA taken upon arrest. Plus, there would be requirement to register as a sex offender under Tier 3, which is the most severe in the state of Michigan, which is a registration for the remainder of life with up to quarterly reporting. Now that charge is going to be dismissed if you enter a plea of guilty to, and I accept that plea, to an added count 2. Added count 2 would be attempt to commit criminal sexual conduct in the 2nd degree. Same thing, under a person under the age of 13, where you were 17 years of age or older. Now, when it's an attempt, it does a couple things. For instance, there are what's called of the Michigan Sentencing Guidelines. And you've heard a little bit of talk about that already, and I trust that Mr. Champion's talked to you about it. Now, there are different classes. For instance, we have classes A through H. Well, when it goes down to an attempt, it changes grids and goes down to a less serious grid. We're going to talk about that in just a moment too. But anyways, a plea to attempted criminal sexual conduct, or conduct in the second degree, would be still a misdemeanor. I'm sorry, felony. Sorry, thank you. I don't know where that came from. Forgive me. I got a lot of stuff going on here today, but it is still a felony, and it's punishable by a maximum of up to 5 years, plus registration underneath the Sex Offender Registration Act as a tier 3, which is still the same. It's for life and requires quarterly reporting. There is, however, not the requirement to have lifetime electronic monitoring. Now, when I talked to you about the Michigan Sentencing Guidelines, I told you that there are these grids, and what Ms. House is telling me, which Mr. Champion, as I understand, agrees with. Those grids give the court a suggestion as to what an appropriate sentence would be. And I'm told, for example, that if you were convicted of criminal sexual conduct in the second degree as charged, they estimate that your guideline range, the minimum end, would recommend to me a sentence somewhere between 36 and 71 months. They're also telling me that, at least in their estimation of the guidelines, if you plead guilty and I accept the plea to an attempt CSC 2, it would be a 7 to 23 range. Now, that's really important because the agreement today is that you're going to allow me to exceed those guidelines. Now, the Michigan Sentencing Guidelines are not mandatory upon a court. They are, however, a tool that we are required as judges to use in establishing a sentence. However, the court can deviate from those guidelines in some circumstances. And I would have to give justifications on the record for doing so. What I'm told here is that the parties are already, this includes you, agreeing that I will be able to deviate from the guidelines and go and give a minimum of 38 months. Right? And that means the maximum would be up to the 5 years, or in other words, 60 months. You heard Ms. House talk about this 2/3 rule. There is a statute here in Michigan that says whatever the maximum is, a court cannot give more than 2/3 of that maximum. Well, this 38 months obviously is within that or below that 2/3 maximum. So I think it would still be a legal sentence, especially if the defense is agreeing to it. Do you understand so far? Mm-hmm. Okay. Now, when I ask you questions, I'm not offended at all. Don't worry, you didn't do anything wrong. When I ask you, make sure you say yes, no, and give me words, only because Nancy has to take words down. Okay?
Okay.
All right. Did you understand everything I said?
Yes.
Do you have any questions about what I said thus far?
No, sir.
Okay. Now, Mr. Champion handed to me before we began this morning a piece of paper that at the top says advice of rights, and at the bottom appears to have your signature. Is that your signature?
Yes, sir.
Now, did you read through these rights before signing?
Yes, sir.
And did you understand what you read?
Yes, sir.
And you understand that by pleading guilty, and if I accept that plea, you will be waiving these rights?
Yes, sir.
Now, because of the nature of this offense, I want to make sure that even though I've got that signed advice of rights, that you and I talk about it. If you enter a plea of guilty and I accept that plea, you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses, the right to have the court order any witnesses you may have for defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at the trial if you chose to testify. Mr. Birch, do you understand all those?
Yes, I do.
Do you have any question about them? And again, do you understand that if you plead guilty and I accept that plea, you will be waiving those rights?
Yes, sir.
Additionally, any appeal that you would have pursuant to the plea and the sentence, which is based upon this pretrial agreement, you couldn't file what's called a claim of right to appeal. That means that the Court of Appeal has to look at it, has to entertain it. You only get a claim of right if you've been convicted at a trial. Because it's going to be a plea and a sentence. Any appeal would be done by filing a different process called an application for leave to appeal. Furthermore, you may be given up the right to appeal issues that would only otherwise be appealable if you were convicted at a trial. Also, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today. So what I need to do is make sure that you're making this choice of your own free will. Are you?
Yes, sir.
Have there been, other than the terms that I've already talked about, have there been any other promises, threats, coercion, duress, or terms of the agreement that we haven't discussed? Okay. Now, again, I know we've already talked about this potential sentencing. Now, I've already expressed my intent to comply with the agreement, okay? Let me explain this. I'm very cautious because if I do this, then it looks like I'm breaking a policy. And I like to state it on the record so no one brings it back up today. There are different ways to enter a pretrial agreement with the prosecution and the defense. So I like to tell people, imagine there is a triangle agreement to there, and then to me, and then back to you. That's called a Cobb's agreement. I generally don't do Cobb's agreements. A Cobb's agreement, that name just comes from an appellate case. It says the court can agree right now as to exactly what the sentence is. I don't do those. I don't do them because I don't know anything about a defendant. Now, in this particular case, I've already agreed that I'm going to go along with the agreement. I'm just kind of covering my tail because I don't want anybody else to come in here and say, oh, Judge, you changed your policy. No, but these counsel and I have talked extensively about the case, and I understand why we're going to here. The other kind of agreement is a line between you and the prosecutor. That's called a Killebrew agreement. That's where you all reach an agreement. And if I don't go along with that sentencing, you would have the right to withdraw your plea, come back to the stage of the proceedings. So I do have to ask one small question here of the counsel. Is this an agreement that the minimum will be 38 months, or is it a minimum, or is it an agreement that that's the lowest I can go? Because that tells me whether or not I'm agreeing to a Cobb's or a Killebrew, and whether or not I go above or below that. I'm sorry, above it.
The offer has been that would be this.
Okay, I just want to make sure. Now, the reason that question is important is because it tells me we are not doing a Killebrew agreement. We're really kind of doing a Cobb's agreement because I'm trying to provide everybody some security and sense of understanding. And that also tells you that when the prosecution comes and we have victim impact statements, I'm not going to go above the 38. That makes sense? Yeah. If we had the Killebrew agreement, like I talked about, which is the line between you and just the prosecutor, they could come in, they could argue, and I'd listen to victim impact statements, and it could go up as long as I didn't pass the 2/3, of course. And by the way, it's not a whole lot further. It's only a couple months, but anyways. So I'm telling you that in effect, this is a rarity for me. In other words, I'm agreeing to the sentence now. Now, if for some reason I don't go along with it, which I can't imagine, I could try to withdraw from it. The only way that would happen is if I somehow find out that your criminal history record is a lot longer, that you are wearing a mask and you're really a assassin wanted from all over the world, right? But as long as everything's the way they're telling me, I'm going to go along with it. Do you understand? Yes, sir. All right, great. Do you have any questions about what we've talked about?
Yes, sir.
Now, I'm about to turn next to the step where I ask you what your plea is, and then I have to ask you to tell me what it is that you did that makes you guilty of this offense. Before I do so, do you have any questions at all that you need to ask Mr. Champion?
No.
And you've had enough time to speak with him about this plea?
Yes, sir.
All right, good enough. Thank you. Mr. Birch, as to the added count 2, attempted criminal sexual conduct in the second degree, how do you plead?
Guilty.
Now, before the court accepts that plea, I'm going to need you to tell me what you did that makes you guilty of that offense. So before we do that, I'm going to start, or as we do that, I'm going to start to ask some questions. Just going to ask.
You need to be sworn in.
Yeah. I swear him in.
Maybe he did, and I missed it.
Yeah, I
Sorry, it
did.
was so long ago, I apologize.
It's okay.
Trying to cover all our
Are you
bases.
trying to say I talk too much?
No,
It's okay.
I didn't, I definitely was not saying that. I just want to cover all our bases, and you did that early, and then we did other things.
Don't worry about it. I'm just trying to keep the atmosphere light. Thank you. All right, Mr. Birch, I'm going to turn your attention back to a date. It's about a little over 10 years ago. Back to June 2nd, 2015. Back in here in the city of Cadillac in Wexford County here in the state of Michigan. What did you do? Where were you living at that time?
I was living at 1012 6th Street in a camper.
Okay, was that in 6th Street? Was that here in Cadillac?
Yes.
Okay, and were you living there with anyone else?
I was actually just there to visit. It was my daughter's parent, or my daughter's mom.
Okay.
And her family.
Okay, and what happened? There was some young girl there.
Yeah.
Tell me what happened. Who was she?
That was my stepdaughter at the time.
And what was her name?
Marcia.
Okay, your stepdaughter was Marcia?
Mhm.
Okay, and how old was Marcia at the time?
11.
So she was under the age of 13?
Yeah.
And you knew that, is that right?
Yes, sir.
All right, and so what happened between you and this stepdaughter, Marcia, that was some kind of sexual contact upon her? Tell me about that.
We were sleeping in the camper and I was humping her.
Humping, right. Now this is one of those things that's kind of difficult, and I want you to know I'm going to help walk you through this. When someone uses the word humping, it might be easy to say, yeah, we probably have an idea of what that means. But once you tell me, I'm going to ask you some questions. Were the two of you laying in the same bed in this camper?
Yes.
And was she asleep or was she awake?
Asleep.
And was she clothed or unclothed?
Clothed.
And were you clothed or unclothed?
Clothed.
And were you under blankets or over blankets? Tell me about that. Do you know?
I don't recall.
Okay. And so how were the two of you laying? Were you side by side, rolled on your side? Give me an idea.
We're on our side.
On our sides? Okay. Were you in front or behind her?
Behind.
All right. And then so did you pull her body close to yours or yours close to her?
Yes.
Okay. And when you said humping, what part of your body was touching her?
My penis.
All right. So your groin area was touching what part of her?
Her butt.
Okay. And you knew this was happening?
Yes.
All right. And was she awake or asleep?
Asleep.
Did she wake up at all during it?
Yeah.
Okay. And when you say humping, do you mean you were rubbing up your private area against her private area?
Yes.
Okay. And when she awoke, what did she say or do?
She told me she was cold and she wanted to go in the house, so she went in the house.
Okay. Were the two of you the only two people staying in this camper on that night? No? Who else was present in that camper?
A friend of mine, Michael Yarbrough.
Okay, but was he in the same bed or a different bed?
No, bed across.
All right, thank you. And when you were doing this humping motion, was it for some sexual purpose for you? Were you doing it for a sexual purpose?
Yes.
All right, and so was that because you had some sexual desire that caused you to do it, and that's why you were rubbing up against her?
Yes.
Okay, thank you. All right, Ms. House, do you believe the defendant provided the factual basis to support the plea to the added count two?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with Control 6.302?
I do, Your Honor.
Thank you. Mr. Champion, do you agree with all three?
All three, Your Honor.
Thank you very much. All right, this court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. I further find that the testimony provided by the defendant under oath on the record satisfies the elements, not only for the greater offense, but allows the court to accept the lesser included offense, which is added count two. Therefore, the defendant is found guilty of added count two. Mr. Birch, that means we'll now have to set the case for sentencing. Sentencing typically takes place in about 4 weeks. However, because of the holidays, sometimes it might take a bit longer. Between now and then, a Michigan Department of Corrections officer, also known as a probation and parole officer, is going to prepare a pre-sentence investigation report. This report will include a description of the agreement, description of the facts, what happened. Tell us about the pre-trial agreement. It will also include information that you provide while the report's being made. And it will include a scoring of the guidelines. Remember, guidelines likely, which are an estimate, may be between 7 and 23 months. made an agreement today that the minimum end is going to be the 36 months. I also want you to keep in mind that it's going to have a recommendation. That recommendation comes from that probation or parole officer. I highly suspect that it'll be consistent with the pretrial agreement. But the key point here is whatever it says, it's the court, me, who determines the sentence. And in this particular instance, it's going to be consistent with the facts and the details that we've talked about today. Do you understand?
Yes, sir.
Now, there are 3 steps that involve you in the preparation of this report. Number 1, you're going to get a packet. The clerk has just handed it to the bailiff. He'll give it to you when you leave here. You'll open it up, follow the instructions, and turn it back in. You'll also be subject to an interview with an agent from that department, and you have the right to have your attorney present during that interview. Also, Mr. Champ's going to come back and visit you and go over that report. He generally gets a copy of it somewhere between 10 days, maybe 2 weeks before we come back. Now, it's important that the 2 of you go over to make sure that it's complete and accurate, as I'm going to base the sentence on it, but also consistent with our pretrial agreement today. Each side has the right to come to the court and request corrections or make objections to the contents of the report. Also, when we come back for sentencing, you may receive when we get that report back, there might be a victim impact statement. However, I remind you also that a victim, which can include the young girl, who I now understand is obviously also a small point. We forgot this point. Mr. Burke, how old are you at the time? How old are you right now?
I'm 33.
And at the time, therefore,
34, sorry.
I'm sorry?
I'm 34.
All right, so back at the time, you were 17 years of age or older, at least, it sounds like.
I was 23.
23, 24, all right. The court reaffirms its finding as to guilt as to count 2. Thank you. We may hear from the victim. We also, dependent upon her age, I don't remember what it is, I don't even know right now, we might hear even from a parent. Okay? Do you have any questions about what we have done today, Mr. Birch?
No, sir.
Do you have any questions about what's going to happen next?
No, sir.
All right, thank you. Mr. Champion, anything further?
Nothing further, Your Honor. Thank you.
Court revokes bond. I'm required to. And therefore, anything further, Miss Hunt?
No, Your Honor, thank you very much.
Thank you very much. We are adjourned.
38 months, not 36, correct?
Correct. 38.
Thank you.
Sorry, if I said 36, I apologize. Thank you very much, Karen.
Okay, just to clarify, because we had some questions in the chat about what Judge was saying with regards to 2/3 the maximum. So I looked it up, and I thought that Michigan had this, but I wanted to make sure that I had clarity on it to share with you. This is called Michigan's 2/3 rule, but we either misheard what he was saying or he misspoke. So what the 2/3 rule means is that for the minimum, the judge cannot exceed 2/3 of the maximum sentence. So, for example, let's say the maximum sentence for a particular crime is 15 years. 2/3 of that would be 10 years. So if he sentences in a range, the best he could do, the worst he could do, rather, would be 10 to 15 years. He couldn't go like 12 to 15 or 13 to 15. It's that minimum portion which can't exceed 2/3 of whatever the maximum for that crime is. So hopefully that makes sense and help clears it up, because it wasn't necessarily making a whole lot of sense prior to that.
Let's recall Noah Alush on page 5. All right, so good morning, sir. You were arrested for aggravated assault on a law enforcement officer, fleeing and eluding a police officer, resisting an officer without violence, and failure to obey a law enforcement officer. Your attorney is here, Mr. Heller. Good morning, Mr. Heller.
Good morning, Your Honor. Peter Heller on behalf of Mr. Alush.
Can I have the calendar, please? The reckless driving, that's a citation, so I don't believe that's the court.
There's a
So, Officer Blanco, you've already been sworn in. Is there anything you wanted to say?
Yes, Your Honor. I'm the victim officer in this case. Yesterday at about 5 p.m.,
The defendant was operating an electric motorized scooter on the beach walk. It speeds about 30 miles an hour. I attempted to stop him. He accelerated to avoid me, striking me, knocking me to the ground and injuring my right elbow. When I was on the ground, I looked at him. He saw me, and instead of rendering aid, he decided to jump back on and flee. He led officers on a chase throughout the city. We were finally able to apprehend him. Your Honor, I'm asking for an elevated bond. He's a resident of California. He has a California driver's license. Clearly, he will flee from law enforcement. And I believe that without an elevated bond, he's going to be a flight risk and come back to court.
Okay. State, do you have any questions for Officer Blanco?
No questions.
Mr. Heller, any arguments or, I'm sorry, do you have any questions for Officer
I just
Blanco?
have a quick, you say he's a resident of California. You have his permanent address is listed in Miami, though.
Your Honor, I researched the records. He has no Florida driver's license. His only ID is from the state of California.
Okay, so the address of 5750 Southwest 56th Street, do you know how that was ascertained? In Miami?
I'm not the arresting officer, so I don't know, but I could not
Okay.
find a local address for him.
All right, and your assertion is that he intentionally drove towards you with one of these scooters that you stand on? Is that what it is?
Electric motorized scooter. It's not street legal.
Okay, I understand that, but is that the ones, when I'm thinking of scooter, is that one that you stand on? Is that what you're talking about?
Yes.
Okay, and how fast do those go?
Well, the legal ones are maxed out at 20, some at 28. The illegal ones, the off-road use only, which is the one your client had, is made to go 60 miles an hour.
60 miles an hour?
Correct. They're not street legal. Those are
Wow.
off-road use.
Okay. Now, I have no further questions for the officer, Judge.
Lydia, are you there to put the camera on the victim? You can see his arms bandaged up.
No, I'm not disputing, what he said at this point.
Let me finish reading.
I just don't know if there was intent. That.
Well, you're
remains
not
to be
allowed to
seen.
ride an electric scooter or anything motorized on the beach walk, which is probably why he was there and doing enforcement.
Yeah. My guess is he probably got scared. I don't know, but I can't imagine that he was going to run directly at him to try and hit the officer with a scooter. It doesn't make much sense, but I'm not going to dispute what the officer felt. It's his,
He went on
his reasonable, excuse me.
Evading several other officers with lights and sirens, evading them. The only reason why we caught him because he hit a dead end over on Biscayne Point. But he had no intention of stopping.
Okay, well, what his intention is that it's to be determined. But I'm not arguing with you, sir.
Just give me a second to read the arrest affidavit. What did
Yes, please. And I don't believe he has any priors. Is that correct, State?
Oh, okay.
So some sort of domestic arrest in 2013 that I don't have a disposition on. It looks like Missouri. That's the only thing that came up. Also, I put in his area code on his phone. It looks like that could be Ohio. I don't know what he's doing in South Florida.
Your Honor, that's also to my point. His Instagram, where he posts all these videos, is called Nomadic Noah. Nomadic meaning moves around all the time.
Judge, I was contacted by his boss. Said he's working here locally. I don't know what he does.
So he had to be tased to be stopped. Okay. And just, officer, what are your injuries? Because he's charged with aggravated fleeing and eluding a police officer. It should be after accident or injury. But what is your?
I have a hairline fracture on my elbow, and I have to undergo further treatment and see what tissue damage I have. So I have a follow-up next week.
Certainly wish the officer well.
Thank you, Counselor.
So, count one, I don't know what bond you're seeking, but officer's asking for an increased bond. He may be a flight risk.
I don't believe he's a flight risk, but if he doesn't have any significant priors, Judge, I would just ask, because he does work here. I can ask him what he does. I don't know. I just spoke to the representative for the boss.
Your Honor, and my legal counsel, I'm a graduate student at the University of Miami. That's
okay.
So count one's aggravated assault, it should be on an officer, an aggravated battery if he has a hairline fracture in his elbow.
Yeah.
Am I able to speak at all?
Yes, sir, you're presumed not guilty. Mr. Heller's a very good lawyer. You should listen to what he tells you and you'll speak to him privately. I'm just finding probable cause for whatever's on the arrest affidavit or based on the testimony presented. So count one is probable cause for aggravated battery.
We just asked for standard bond, Your Honor.
That's $15,000 bond.
Is that
The first degree felony.
right? It bumps it up, right?
He's lucky he's not being held. No bond on that. Count two, fleeing and eluding a police officer. There's probable cause for that charge after accident or injury. That bond will be $5,000. Count three, there's probable cause for resisting an officer without violence, $500 bond. Well, 3 and 4 are similar. 3 is resisting without, that's 200. I'll split those. Well, what's the bond on count 4? Correction?
Count 4 is the traffic. He'll be going to jail.
Oh, so that's not even before me. So count 3 will be $500. So the failure to obey a law enforcement officer and the ticket for reckless driving will be heard now in courtroom 5-3 before the county court judge. If you want to go there, Mr. Heller, that's going to be next. All right. So the total bond here is $20,500. All right.
Thank you, Judge.
And on case number 25-0000127 for purposes of sentencing, defendant is present with his counsel today, Ms. Rachel Smith. On case number 25-CR127, we were last here on July 8th, at which time the defendant entered a written and oral plea of guilty to failure to comply with order of signaling a police officer, felony of the 4th degree in violation of 2921.331B. Count 2, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, misdemeanor of the 1st degree in violation of 4511.19A1A. We were originally set for sentencing on August 25th of 2025. The defendant did not appear. As a result of his failure to appear on 2 separate occasions, case number 25-CR001313 was filed, and that is 2 counts of failure to appear, felonies of the 4th degree in violation of 2937.99.
All right, we're going to deal with case 25-CR1313 first. It's matter scheduled for an arraignment. Mr. Atwater, did you receive a copy of this indictment charging you with the 2 counts of failing to appear?
Yes, Your Honor.
Have a chance to look that over?
Yes, Your Honor.
You have the right to have me read that indictment to you, and I'll do that if you'd like me to, or you can waive the reading. What would you prefer to do at this time?
Waive the reading, Your Honor.
Very well, then as to those 2 counts, how do you plead at this time?
Not guilty.
All right, the court will enter a plea of not guilty. And I'm going to set bond at $10,000 cash surety. All right, now in regards to case 25-CR127, Ms. Smith, is there any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Is there anything you'd like to say on behalf of your client?
I would, Your Honor. Mr. Atwater is before this court on a failure to comply case. Mr. Atwater is a veteran. He served in the Marine Corps. He was twice deployed, suffered a traumatic brain injury that was documented from an explosion. Prior to finding himself before this court, he was established with services with the VA attending once a month, and working on obtaining a therapist. Your Honor, Mr. Atwater's PTSD kicks in as fight or flight, and for him it registers with flight every single time. It's how he came before this court on the underlying offense. It's how he came to flee his sentencing hearing. But he was re-entering the country from Canada after fleeing to see his family for the holidays and then turn himself in. Obviously, he was unable to complete the first part, but he is before the court humble and apologetic. Mr. Atwater understands that under the laws of this state, the court has no option but to send him to impose a prison sentence in this case, despite the fact that at the change of plea, it was offered that there was a joint recommendation for community control in this case. Mr. Atwater also pled guilty to an OVI. His drinking is as much tied to his service and his resulting disability. And despite being incredibly intelligent, incredibly respectful in most of his dealings with individuals, although not in complying with this court's orders, Mr. Atwater understands the court will be imposing a prison term today. He would like the court to consider the role that his PTSD does play in each of both the offenses to which he's pled guilty and the
Well, you're asking me just to assume that. I have nothing about that. I gave an opportunity to provide me information on that, but he chose not to do that.
And Mr. Atwater understands that the only reason that the court is very likely imposing a prison sentence here is because he has mtake it. So the court has no other options.
But my point is, you're offering these explanations, and I guess I'd like to take your word for it, but I don't have any.
Am I allowed to speak, Your Honor?
You'll get a chance in a moment.
And Your Honor, that is the purpose of a pre-sentence report, and that's why it was critical that it take place here. It did not, and it did not because Mr. Atwater did not appear. And so, Your Honor, we are asking for leniency in the prison sentence that is imposed. Mr. Atwater does not have a criminal history. He does have a record of service with this country as a veteran, and I believe that he intends to indicate his remorse and regret to the court in his own words as well.
Thank you, Ms. Smith. Mr. Atwater, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Your Honor, I'm deeply apologetic for the decisions I've made, and this is the most trouble I've ever been in my life, and I've never, a lot of these terms are very new to me. Please, copy please, just the whole situation is I was completely oblivious to. So
show up to probation by 9. That's confusing?
Not confusing, just wasn't feasible, Your Honor, because there was.
And you should have stayed in jail. I gave you a bond because you told me you'd be able to do it.
Your Honor, this is the most time I've ever been in jail. It's a terrifying, scary situation. I have kids. I've never been away from them besides the time of me being at war. And I felt like the time I had spent in jail was worse than war. Like, it completely was. I don't have anything as far as like to say. When I said I could show up, I was planning on finding a way. My mother was out of town. She was in another country, and I was just under the influence. I wanted to get out of jail at that time, and I tried to find a way, and it didn't work out in my best interest, Your Honor. I'm apologetic about that as well, and I just want to say I don't go out with any ill intent of doing any harm to nobody. I've never stole from anybody. I don't be in the world doing anything wrong. Most of the history I have is just driving. The one thing I did on that instance in January, all I was doing is trying to avoid a confrontation at home. I went to the bar, I drove home, and in this situation ensued. There was no craziness as far as like I'm not out here doing anything wrong. I'm just trying to raise my kids. I take my kids to football games, cheerleading practice, you know what I'm saying, the normal dad stuff, and just try to live in the world as peacefully as I can. I've been to 3 different trade schools. I do home renovations. I do a lot of different things to not be in trouble or getting in this type of situations. That night was me trying to avoid a situation, and it happened to be this is what happened from it. So I apologize for just the whole situation in totality.
All right, thank you, sir.
Thank you, Your Honor.
Ms. Smith, anything else?
Not at this time as to this matter, Your Honor.
Give me 1 second. Well, Ms. Linden, on behalf of the state.
Thank you, Your Honor. Your Honor, I know we did originally say that we were going to have a joint recommendation for community control, but the problem is that you're going to be on community control, you have to show up. And it's clear that that is a difficult thing for the defendant to do for whatever reason. So the state is recommending a prison term on this matter. He does have 8 days of credit for time served. There is a requisite driver's license suspension on the failure to comply of 3 to life, and then on the OBI of 1 to 3 years. There's a mandatory 3 consecutive days for the OBI, and then a mandatory fine as well. So we'd ask that you impose those. Thank you.
Thank you.
Your Honor.
Hang on 1 second, please. Ms. Smith?
Your Honor, it's my understanding that Mr. Atwater has 8 days of jail time credit since his arrival.
Yeah, that's exactly what I'm doing right now.
Okay.
Let me look see what I get. Do you have a number?
I do not, but there were, based on my records, it appears at least 3 other times.
Well, he's
that
been
he
in
was
jail several times.
Yes.
Your Honor, it was, the original jail time was from November 22nd to November 24th.
January, you mean?
I'm sorry, January 22nd, I'm sorry, January 22nd and January 24th. Then after that, from July 7th to July 8th, and now he was arrested here on the 24th, is in custody and until today's date. That's where I came up with 8 days.
When was he was arrested?
On this case?
Yeah, and now, recent?
Now, 24th.
That was the date of arrest or the date he arrived in the jail?
I have from...
What date were you detained at the
From Deputy Robertson
Monday.
from the Marshal.
Talking about the burning here?
Apprehended on the 24th.
Okay.
Was in custody then.
Here, but let me look at something first. I mean, I'm looking at the docket. I mean, his bond's been revoked 4 times in this case. So back in February of this year, there was a motion to revoke his bond that was granted. The warrant was issued on February 19th, executed on the 20th. So he was arrested on February 20th. Then there was a hearing on a motion to reinstate. And the judge reinstated it at that time, but that's 5 days there. 20th, 21st, 22nd, 23rd, 24th. That's 5 days in February, 3 days initially. Then the next month, a motion to revoke bond was granted. He was arrested on March 31st. Motion to reinstate was filed, and that was granted on April 8th. So the 31st through April 8th, he was in jail. That's 9 days. No, my computer's not working. And he was arrested on the 7th because he showed up late for the change of plea. We got him in the next day for the plea, correct, on the 8th?
Yes,
And that's when he was released. So that's the 2 days you have there. And then you're saying he was arrested on 11/24
Yes,
till
sir.
today. 3 more days.
22 then?
I don't know yet. 14, 16. I got 20. Am I adding wrong?
3 original, then 5, plus 9, and then another 5.
22.
Oh yeah, 22. All right, this court has considered the facts and circumstances of the offenses involved here, the nature of the offenses involved here. Consider the history of this case. I don't have a pre-sentence report to review as an psychological evaluation that were ordered by this court as the defendant failed to appear to the probation department to assist in the preparation of those reports, which would benefit him, benefit the court. I've considered everything that's been said here today by Mr. Atwater, his lawyer, prosecutor. All this is considered only the purposes and principles of felonies. I'm sorry. Felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually in regards to the stated factors. However, the court will note that for the fleeing and eluding charge, the defendant was operating the vehicle under the influence of alcohol or drug abuse at that time, which makes the fleeing charge more serious. Nothing makes it less serious. As for recidivism factors, the court notes, while the defendant may not have a criminal history, he has a horrible traffic history with multiple driving under suspensions, which this coincides with the conduct here throughout, just not following rules and not following orders and court orders. And he just does what he wants to do. Appears to be an alcohol problem, at least related to this offense, and hasn't done anything to address it. I don't find genuine remorse. I could find genuine remorse just coming here today and saying I'm sorry, but the conduct and your behavior leading up to this shows no remorse. And other factors indicating relevant factors, just the fact that the defendant's bond has literally been revoked 4 times in this case. First, sit down, please.
Yes, sir.
First 2 times, it's because he wasn't able to pay for the, whether it was Scram or GPS, I don't remember which one it was, and it was revoked and reinstated. And it got revoked and reinstated. Then in this case, he shows up late for his plea, so it was revoked and reinstated. I've never seen that happen before. Someone's had their bond revoked 3 times and then been reinstated every time. And that's part of the problem here. You think you can just do what you want to do and you're going to get what you want, and then I'll end run. And then it was violated, revoked again because the defendant, when I reinstated it, when he got reinstated for the 3rd time, he was told to show up the next morning by 9 a.m. He didn't show up. Didn't call. Didn't come the next day. Didn't reach out at all. Said you didn't have a ride, but nobody knew that. You didn't call anyone to tell him that.
I was under the influence. I was going to jail, Your Honor. That's all.
It's not an excuse.
Not an excuse. And I feel like there was a lot of miscommunication with the Scram monitor because they said they was going to pay for it, and then I got bound over to Lake County, and then they never told me that I had to pay for it. That's where all of that miscommunication came from initially for the Scram.
Even the second time?
Yes.
When you got it revoked and again it was reinstated? And you said you would pay for it?
I was paying for it, Your Honor, but they didn't tell me that I had to pay for it. It was surcharge every day. So I was paying for it weekly, but by the time I paid for it the next week, they were saying that I was late. That's what that was about.
You know what it's about.
I didn't know that I had to pay for it ahead of time.
You keep saying you don't know this stuff, and this stuff's explained, but you just don't pay attention or you don't want to hear it. You claim I didn't know I had to be there by 9 o'clock, or maybe it was your girlfriend who called here. Your girlfriend that called here and said he didn't. It was never told what time he had to be there on that day. Well, that's.
I knew I had to be here at 9 o'clock, Your Honor. I just didn't have a ride from Cleveland.
Bond's been revoked 4 times. You've had multiple license suspensions because you just do what you want to do.
All I've done was go to work, Your Honor.
I gave you say what you want to say, because it's my turn to speak, but apparently you have more you want to say. So I'm going to let you say what you want to say, but then it's going to be done. We're not going to go in this debate here.
Yes, Your Honor.
Is there anything more you want to say?
No, Your Honor.
So his bond was reinstated when after he showed up late for the plea. Didn't show up to any of his appointments, didn't call, reach out, and do anything. Showed up for his sentencing, and he left. And he's been gone September, October, November, over 3 months. 3 months.
Terrible person, yeah.
Attempted to leave the country.
Never left the country.
I said attempted to leave the country. We're not having a debate. I said attempted to leave the country. You were going to leave the country.
Never attempted to leave the country.
Your attorney just said it. And I knew you were arrested of someone trying to get near the Canadian border.
No, I was not, Your Honor. That is false information. I was arrested at home. I don't know where Canada came from.
From your lawyer's mouth.
It was relayed to me by the state, Your Honor.
Your Honor, I can just tell you from
Go ahead.
what the marshal said.
I was at home.
So in terms of.
You're going to be removed from this courtroom if you're not going to keep quiet.
Yes, Your Honor.
I've given you every opportunity to speak. I've asked you multiple times if you have anything more to say, and I said we're not going to argue back and forth, and you keep doing it. It's the exact history of what this case is about, that you just do what you want and don't listen to anybody. Ms. Linden?
The information from Josh Robertson from the sheriff's office indicated that they had to ping his phone, that they got the phone number that was pinging within 25-meter radius of Windsor, Canada. It was across the river from Detroit. He had to reach out to Border Patrol to see if he's crossed over, and they were looking at a provisional warrant to give to Canada as a result of that. There was a Canadian counterpart that they were trying to get in touch with as well there. They were going to continue to ping the phone, and then he appeared to be the next day back in Detroit, and they were going to reach out to Detroit at that point in time, and then they continued to ping his phone, and then he was finally apprehended.
Thank you. So again, there's a history here of not complying with court orders and rules. As for factors indicating recidivism is less likely, the court notes the defendant doesn't have any criminal history, led a law-abiding life for significant, well, he doesn't have a criminal history. I'm going to say he's led a law-abiding life because he's got a horrible traffic history, and that's not following laws or abiding by the laws. Again, the defendant failed to appear for a pre-sentence report, so I don't have a report that was completed, and thus I don't have the, under the law, the authority to impose community control sanctions. When I look at the history of this case and what this whole thing's about, there's no way the court could find the defendant's amenable to community control sanctions. The very offense itself deals with failing to comply with an order of a police officer. The defendant's bond again was revoked 4 times in this case. The history here is that he doesn't comply. Doesn't follow rules, and he's going to do what he wants to do. So prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that on count 1, Defendant served a term in prison of 12 months. Count 2, he served 180 days. By law, that must be concurrent. So 12 months in prison. He has credit for 22 days he's already served. Need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half the term I just imposed, which would be 6 months. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. There's a mandatory license suspension for both counts that's required. I'll suspend the defendant's license for count 1 for 3 years, which is the minimum. 1 year in count 2, there'll be a concurrent suspension. There's a mandatory fine in count 2 that must be imposed. I'll impose the minimum fine of $375. Defendant's also ordered to pay all costs. Is there anything else for the record, Ms. Linden?
No, Your Honor, thank you.
Ms. Smith?
Your Honor, only that in case number 25 CR 1313, Mr. Atwater has executed a waiver of speedy trial in the bond conditions.
Okay, we'll get that filed. Thank you. Anything else?
Not at this time.
Thank you.
All right. 41591, the state of Texas versus, God bless you, Jacarius Avante Francois. That's you.
Yes, sir.
And you were here with Mr. Turk, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in a summary fashion? In summary, sir, this indictment alleges that on or about December 13th, 2022 in Jefferson County, Texas, you committed a third-degree felony of assault on a pregnant person. Do you understand what you were charged with?
Yes, sir.
A third-degree felony is what this case is all about, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement has been reached in your case where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. And there would be terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty?
Guilty.
What do you say?
Yeah.
Okay. Are you pleading guilty voluntarily and because you are guilty? I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents true and correct?
Yes.
State's Exhibit 1 tendered into evidence without objection admitted without batterers and intervention presumption. How long was he in jail? Thanks. Thanks.
Judge, Mr. Francois said he was in jail for 5 months.
Among other things, this states Exhibit 1 that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged as any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
Stand up.
a record show he was in custody for 153 days on the
That's
charge.
what she says. Yeah, that's what it's showing. Y'all are working off the same page. That's great.
So, thank you. The test.
All right. Anything further on this?
No.
I'm going to make the findings that, and again, you are pleading guilty today voluntarily and because you are guilty. All right. I'm going to make findings based upon State's Exhibit 1 here that's been signed. That this states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And you are guilty of this crime and any lesser included offenses. I am going to find, indeed, you are mentally competent to enter this guilty plea. It is freely and voluntarily made, even though there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I'm going to defer any finding of guilt, follow this agreement, and place you on deferred or unadjudicated probation. This will be for 10 years. You do well, it can be shortened to 30. There will be terms and conditions of probation which are focused on this type of case.
I need to interrupt you on, on these type of matters. This is an area in which the court cannot reduce the amount of time for on the probation on domestic violence related.
I know. I'm going to place him on 10 years deferred or unadjudicated probation.
You made the statement that you, if he did well, you could reduce it by a third.
Okay.
The law says that you cannot.
I'm sorry.
We also discussed a 5-year defer.
And that's one of the reasons why I agreed to 5 years. And I hate to interrupt the court, but that's the reason why I interrupted the court.
Okay. On this Family Violence Act.
Yes, sir. So I'm asking that you approve the 5 years, Judge.
All right, then the court will, and that's agreed upon by the defense. I'm going to follow this recommendation of both parties, and you will be placed on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. The court is looking at this probable cause affidavit, which is most disturbing. You're with me? This is for you. This probable cause affidavit is most disturbing. Okay. The victim here was 5 months pregnant with your child. She was taking a shower when you went over to her house, punched her in the stomach. The pregnant lady punched her in the stomach. She was nude. She was unable really to be able to defend herself, put in a bad spot. She says you also picked up a kitchen knife and stated you would kill her. You broke her phone. Police were called. They had visible injuries to her face, scratches on her chin, swollen side of her face. You fled, of course, before the police could arrive. And then, since the incident had occurred, according to the probable cause affidavit, you subsequently called her threatening violent acts. What else could you have done wrong? I can't imagine really a more selfish act could be done than punching a pregnant woman in the stomach. Shame on him. Mr. Man, Mr. Gentleman. And it's your child, right?
Yes, sir.
Punching the mother of your child's stomach, 5 months pregnant. Well, it's about as low as it can get. You've got 153 days. I can sentence you up to 180 days as a condition of probation, and you're going to get all of that. You've still got 27 days to go. You're going to go back to jail. You're going to get every minute of jail that you can. Don't look at him, look at me. I can sentence you as a term of probation to 180 days. You have 153 days credit. You're going to do 27 more. To the last second for this. Yeah.
If I may, Mr. Francois has seen the error of his ways, and he is currently enrolled.
How does he take back punching a pregnant woman in the stomach? And he's seen the error of his ways? He has? How long did that take? I mean, I don't mean to be facetious, but this is clear to everybody on this planet that this is wrong. And I couldn't care less the way you think about this. Really? What are you upset about? That you're being held accountable to assaulting a pregnant woman? This upsets you? You find something unfair about this? Speak. Do you? Or do you think this is atonement for what a terrible error you did? Or am I putting words in your mouth? Because I don't hear much regret.
Your Honor, I'm not saying anything I did was right.
Okay. All right. So, yeah, go ahead.
Yes. I have made changes in my life.
How do you take back punching a pregnant woman in the stomach? And what kind of harm can that do to a fetus?
I can't.
Immeasurable. No, you can't. But you can, by your actions, do better. You can also, by the terms and conditions of probation that I'm going to set, be an example for others that this is not acceptable. You're going to talk to him while I'm speaking to you? Is this boring you?
No, sir.
What?
Judge, if I might finish.
Go ahead.
He's been on bond for 2 years at this point, had no issues. He is currently enrolled in a welding certification process. He graduates next month. So putting him in prison right now or in jail thwarts his entire life. I understand what I'm saying is at that point you're setting.
You think I'm sorry for him? I feel sorry for the fetus and the pregnant lady who he punched at 5 years, at 5 months pregnant. That's who I'm feeling concerned about. Or am I missing the boat here, gentlemen?
You're not at all, Judge, but I will.
He's going to do 180 days, and he still has 27 days. Do you work on weekends?
No, sir, only Monday through Friday.
Okay, then you can serve it on weekends, so you can keep your work. Okay. You check in at 6, on or before 6 o'clock every Friday, you've got 27 days.
Yes, sir.
To do it on successive weekends.
Yes, sir.
And you're going to begin this coming Friday.
Sir.
Thank you,
Weekend after
Judge.
Thanksgiving,
Sir?
the weekend after Thanksgiving, this Friday.
This weekend.
Okay, just making sure I understood.
No, yeah, this weekend.
This weekend.
I just,
It's been cool.
I mean, this is the kind of thing that's not even a question. This is clear that this is most serious and disturbing. And how you thought that this was going to solve any kind of relationship problem, it defies imagination of any reasonable person. And it wouldn't be, I wouldn't be doing my job if I didn't stand for something. And that is, this kind of behavior deserved punishment. And I'm not going to be light on what I can do under these circumstances. I'm going to protect fetuses and pregnant ladies. I have a feeling that you regret what you did. I really do. But I wish you would have called me an hour before you went over and said, "Yeah, I'm about to do something foolish. Help me make the right choice, Judge." And I'd have helped you, because this one is clear. This was a bad choice, and you're just lucky that is the child fine? Appears to be fine. Well, then thank our Creator for taking care of it, of the child. But it wasn't because of you. Are you going to take care of the child in your responsibilities under the law?
Yes, sir.
And nature?
Yes, sir.
And treat the child with love?
Yes, sir.
And the mother, y'all didn't get married or anything. No. But nonetheless, are you going to respect the mother of the child?
Yes, sir.
Those are going to be the orders of the court. You got to report on or before 6 o'clock p.m. So.
15th day of November 2025. The board here, as you can see, is Mr. Tillis to my left, Mr. Freeman to my right, and I'm Steve Prater. We'll be handling the revocation hearing for Mr. Henry Clifton, who is at East Baton Rouge Parish Facility. Is there any staff from East Baton Rouge in the room?
Yes, sir. Lieutenant Murphy.
Lieutenant, thank you for hosting us today. We appreciate that very much.
You're
Mr.
welcome.
Clifton, would you tell us, you are Mr. Clifton, correct?
Yes, sir.
Okay, Mr. Clifton, what's the purpose of the mask?
The mask is for tuberculosis, whatever they got going on here. I'm just trying to keep myself from getting sick.
Okay, okay. Would you is that okay if you take it down for now so we can hear you and see your lips moving?
Yes, sir.
Okay, thank you, sir. Okay, your case, well, let's see, what's your DOC number, sir?
531107.
Okay, and have you signed a waiver form of the hearing, agreeing to this hearing today, and understanding that you're going to have a lawyer that it'd be a privately funded lawyer?
That's that paper in front of you. Yes, sir.
Okay, did you sign that paper?
Yes, sir.
Okay. All right, Mr. Tillis to my left is going to be handling the questioning and calling on your supporters to speak. So, Mr. Tillis, would you take it away?
Good. Good morning, Mr. Henry. How are you? I'm fairly well, sir. Thank you. Good morning. I'm going to read some violations, and you can plead guilty, not guilty, or with a statement. Rule violation 4. The offender failed to refrain from criminal activities due to an arrest for simple battery on 4/10/2025. The subject was served with protective order on 7/29/2025 and was found to be in violation of the order, failing to leave the residence location 5568 Lancaster Avenue. Hearing continued 10/21/2025. Trial same date. on 10/21/2025. The pending charges of simple battery was dismissed in city court. How do you plead? Guilty, not deal with the statement.
I don't know how to plead with that. I don't understand because this is my first time being in front of the parole board. Now, I guess maybe I should plead with a statement. I suppose my statement would be that the only defense I have is that my charge was dropped. Yes, sir. And that it did not happen in accordance to how it was stated. I do not wish to waste the board's time, sir. I'm just trying to get a good understanding of how this even works. I'm not sure. I've been doing what I could to stay out of trouble.
Okay, you were arrested for simple battery.
Did I commit the simple battery? No, sir.
Okay. Tell us what happened.
Okay. So, my brother I live with, and I was in bed that morning. He was going to work, and his daughter was taking him to work, and I believe this day was her birthday. And so she took him to work and come back to the house and turned the radio on in the living room and had it vibrating the walls. And I don't know if she cared or not, knew or not, or what have you, that there was someone in the house. I believe she knew that I was in the house asleep. And so I made it known that I was in there asleep. I got up and I made my presence known, and I beckoned for the radio to be turned down. She didn't do it. And I went on and went in the living room and unplugged the stereo. She couldn't get up. She couldn't do it because she was dancing on the floor. She didn't even see me when I was beckoning for her to turn it down because she was dancing on the floor. So I walked past her and unplugged the stereo. She got up off the floor and proceeded to stop me from unplugging it. And I left it alone and went back to the bedroom. She called the police. I called my brother. And he came. While they were there, they wrote me a summons. She told them that I put my hands on her. He knew that wasn't true. He pulled up from his job, drove there and talked to the police, and the police released me to him. They just wrote me a summons. And I got in the car with him and we left, and he went back to work and I went with him.
Okay, thank you. Thank you very much. We have rule violation number 5 on 7/29/2025. While the agents were waiting for the subject to vacate the property located at 5568 Lancaster Avenue, and the subject's belongings was a machete. How do you plead?
That's not my machete. It was a shop. It was a tool shop. It's my brother's shop. I was inside my brother's shop. I wasn't in the house. I was in his shop working, doing what I was legally, what he told me I could do, what the court said that I could do. We had just went to court and got that understood that day. My witness is right here with us. My brother Orlando is on the meeting, and he has a copy of the order that the judge put in place.
Okay, we'll ask him in a few minutes.
Yes, sir.
Rule number 10, the subject failed to pay in supervisional fee and is currently $994 in the rear. How do you plead?
Plead guilty to that.
Okay. We're going to let some people speak on your behalf, which is your brother who is on Zoom. Mr. Henry, what can you tell us about your brother?
Good afternoon, Paul Borough Board. Thank you for allowing me to speak on my brother's behalf. Yes, I invited my brother to stay with me upon his release in December of 23. And he was invited to stay. I want to help him and continue to want to help him get back on his feet. I even had him doing some odds and ends jobs with me with the various things that I do. I set up sound for local bands in my hometown, and that means moving equipment, speakers, mixer, microphone, cables, and that sort of thing. So he comes with me to do those various things. I even have friends who also hire him just as a basic labor hand, helping them out in their endeavors. And he's been with me at my home ever since. The problem, the only issue was with him and my daughter. My daughter was not interested in having him at our home, and I did my best to quell her concerns about my brother. He was really just being there, just trying to do his time, his parole time, and work it down. But my daughter just simply did not want him there. And I tried to be the mediator between the two. Not that my brother was causing any kind of issue. Like I said, and this is my daughter I'm talking about. I never want to go against her, but really, honestly, she did not want him there. And we were in the process of trying to find housing just so I could get some separation between the two of them. And, we were really close to that prior to him being picked up. But no, he was allowed to work in my shop. He likes electronics. He works on those, on different things. So I have all kinds of tools in my shop. And the machete happened to be one of the things that was found. Had I known that was not something that was supposed to be even around him, I would have immediately removed it. I had no idea about that kind of thing. But I've got all kinds of tools in my shop. And having access to that was one of them. So I'm sorry that he got that charge for that, but no, there was no purpose for him being charged with that, in my opinion. He's been doing his best to just stay out of jail. I believe this time not right now, but when he got out in 23, I believe him then. He didn't want to go back. And all I'm trying to do is help him meet his criteria, try to help him find work, to pay his bills and become self-sustaining again.
Okay, thank you so much for your comment.
Thank you.
We have Miss Crystal.
Yes, sir.
You go to the podium, please. Tell us what you want us to know.
More so up here, thanks for having me, but more so of a character witness for Cliff. We met, I guess, shortly after he got out in December. And he's a good guy. He had a lot of opportunity when he was out there. He did work with his brother. That's how he worked with his brother. Doing sound engineering. He had a lot of opportunity because he worked on several different projects with me, through other friends. I just know they had a lot of issues, the niece had a lot of issues with him being there, her personal issues, you know. But I mean, I witnessed several things, her slamming the door and things like that, so. I didn't see him do anything to her. So for the most part, I feel like it's kind of just very issues.
Okay, thank you so much for your comment. Anyone else have any questions?
You know, and I'm listening to you, but it looks like you've had problems in the past with that temper a little bit, with that restraining order with your ex-wife and the kids, and then you go down there and I think you took a car and then probation officer had to order you to bring it back because she had a protective order against you. What's going on with that? I mean, and she said she didn't like the way you disciplined the children. How you discipline?
Well, I didn't physically discipline them, but I definitely made sure that I was stern with my children and let them know that they are beautiful and that they are children that needed to have restraint about themselves, because they were in a situation in that I'm not able to be there. So I needed them to have control of themselves and not put themselves in a position to where they would be in jeopardy.
Gotcha. I have no further questions.
I don't have any questions either. I think it's time.
Mr. Henry, I agree kids should have some discipline, and you didn't physically whip them. My vote today is going to be do not revoke.
My vote's gonna be do not revoke, but I don't want him having no more contact with that niece. And I'm ordering you to stay away from that niece. So if you got to live with that resident, you need to find another one, because this is gonna keep happening.
So as we have my brother on the line right now, that is the only residence that I have at the moment.
I'm not letting back around that niece.
I'm actually saying that she doesn't live there.
Okay, she's moved out?
Yes, sir.
Okay.
And your brother also said he's trying to find a residence for you.
Right. Well, when she comes to that house, you leave.
Yes, sir.
Okay. All right. Well, my vote's to do not revoke, but if
Okay,
you see that niece, you are to leave.
Okay, you have 2 votes to do not revoke, and you need 2 votes to carry the day on a hearing like this. My vote would be to revoke you. I think there's too much smoke here. And I think that immediately when you knew there was a protective order for you, you should have left that residence instead of sitting there on your computer waiting on the agents to get there to talk to you. Order of the court doesn't say you gotta not be around this residence until you've talked to your brother. It says don't be around that residence.
Actually,
and so I don't need you to say anything. My vote is to revoke, but I have a single vote. And I got 2 that say do not revoke. So as of today at 10:14, your parole has not been revoked. That's the end of this hearing.
So we need Emily. So we set, we set a sentence date after you pled guilty to failure to submit to testing. You were going to go to your doctor. Did you go there?
I did. It was yesterday.
Did he give you a report?
He gave me just basically like a note. I tried to
Do
read
you have it with you?
I sent it to Emily this morning. It was just like I saw you yesterday, though it wasn't much. So I did reach out. They don't know if there's like 9 to get you a blood. She's on the way. And then they gave me a prescription for something that she said was fine.
So is he saying that you've got shy bladder syndrome?
That and sorry for it.
All right, let me get her in here. And we'll see what the letter says.
It was basically, I saw you yesterday. That was just, gonna show you much.
Well, that isn't enough.
I know it's not, so I said I'd reach back out already.
I need shy bladder syndrome diagnosis.
You did say it a few times, it's just not, no.
It just says, I saw you yesterday.
Pretty much. I saw you meet this person on the 24th.
Let me see what we can do here, okay? Just give me 1 second. See if you need those or not. Unless I keep a couple up here, I could. Okay. Okay. Yeah. All right, so first of all, let me tell you something. You have the right to a lawyer. I'll be happy to provide you with one at public expense if you would like one. Would you like a lawyer to represent you?
Yes.
Pardon? Okay, so let me see what she has to say. Do you have anything to say?
No. They have to, going.
All right. Why don't you have a seat? Just have a seat until she gets back. You know, okay? Thanks. You can sit right there at the table if you'd like. See. All right. Do we have this other gentleman's case here, John, or not?
He has a case with the state prosecutor field.
All right, recalling Eric Stefan Kish, 25F244490. Mr. Tessino, your name?
Emily Tessino.
Sir, your name?
Eric.
All right, you still wish to waive your right to a lawyer? And you don't have anything to say? He says he got a letter from his doctor just saying he was there. That wasn't the point.
That's what I said. I think I responded and said he didn't give you any other information. He said that he gave him a prescription and I looked it up and or he's giving you a prescription. Yeah, so I looked it up and what it says the prescription does relate to the testing issue.
Does?
Yes,
It's going to help him urinate.
yes.
Well, then let's set this for sentencing again. I'm sorry. If you want to go back and get the diagnosis of shy bladder syndrome, I'll require DNA. Is that where you're testing primarily?
Yeah. And all his testing has been fine since. He went the 3rd, the 8th, 12th, the 16th, the 18th, and the 23rd.
You've been testing all those times?
I test them every time. I only missed the one due to this. I go back a lot of this. Like I'll go in the morning and usually go and pop back up later. But
Look, let's just do this.
Sunday it took 3 attempts. I was there.
So all those tests have been negative.
He's on the sober league as well.
Good enough. I'm going to assess costs of $50. You pay that now, I'll keep you on probation. Just make sure you're going, okay? If not, I'm going to need a diagnosis of shy bladder syndrome. Then I'll have them do a pat-down search. Okay. we didn't advise them to do a pat down. I remember doing that on,
We talked about seeing if it helped, but we didn't.
Okay.
So I'm hoping that the medication helps and.
good enough. Good enough.
Okay.
Thank you. Good luck. Thanks a lot. Have a nice Thanksgiving.
Morning, sir. You're Brandon Bell. And this is cause number 24, DCCR 1008. Mr. Bell was previously in court, entered pleas of true in a motion to revoke deferred probation, pled true to counts 2, 3, 4, 6, 7, 9, and 10. And there was not an agreement on probation for aggravated assault with a deadly weapon. And I've received that updated report. Has everyone had an opportunity to review that report?
What time's that?
I have, Your Honor, in addition to some medical documentation that Mr. Remain has provided.
Was that provided to me?
Not,
Okay. I'm sorry.
probably not.
Okay. Is it, what should it have, do I,
Based on the updated report, when it goes into Spindletop and some other stuff, Judge.
uh-huh. I don't know what you're talking about. Yeah, I mean,
These are medical records from Spindletop.
okay,
And there's also medical records of how he lost his leg recently from being run over by a dump truck while working,
okay,
which I think are factors that need to be addressed.
Probably in addition, Judge, if I may, to the fact that you were called the complainant in the underlying case for which he is on probation. It looked like a stretch to even put him on the probation with his history, but she was very adamant about wanting probation or even non-prosecuting, and she came and testified before you the last time the motion was set so that you could advise them both with respect to the no contact order, which I don't think either one of them were following, but I don't have proof of that, but I know
Okay.
that's been a concern, but I had some difficulty with that portion of the case.
okay,
And if the court would also remember, she was expecting another child, they are expecting another child. And
okay.
she's
So what,
also-
I get, go ahead and make argument and then I'll,
She's also controlling the checking account. He's getting settlements and he's providing the money to her for the children. They still have a house together. But he does have a place to stay, Judge, and that is his mom's, which I believe she can't go to. And my argument, Judge, is, if I may, is that he has mental health problems. He's had some problems in reference to possibly smoking marijuana, but I think it's contributed to things that he has gone through in life. As I said, I have some medical in reference to an amputation. Of course, he's lost part of his right leg. That was due to a dump truck backing up over him while he was working. And then you couple that with mental health issues. He was reporting, my understanding was he kind of was talking out of his head, as also reported by his mom. That was also outlined in the updated PSI report. We're asking, Judge, that you continue him on probation. He does have obligations with his significant other in reference to the newborn and making sure that they're taken care of, which he does have the funds that he has to be able to give to her. But if there is some program that he can have that's outpatient to maybe give him some direction. One last time, he was put on probation in April of this year, Judge. We're now in November, but the problems have been going on. But he does need to go back to Spindletop. He does need to say this is what you do or not. I mean, according to The pre-sentence report he is reporting is not like he's not reporting. He's trying to pay or has been paying and trying to do stuff. I think he just needs a little bit of a correction and see whether or not he can do it. And couple all that, I've had extensive conversations with his wife. I've tried to tell her the way it has to be as of yesterday. We've talked over the phone and the way that it would have to be in reference to separation until they learned how to possibly get along together. So that's what we're asking for, Your Honor.
Ms. Malvino?
Judge, would the court like to hear evidence with respect to counts 1, 5, and 8, Ms. Lopez?
I mean, I guess it kind of depends on the
Just in the context of what she has to say.
yeah, for sure.
I call Ms. Lopez.
Ms. Lopez, if you'll raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you may proceed.
Ms. Lopez, would you please state your full name for the record?
Rachel Lopez.
And how are you employed?
I am the high medium risk officer at adult probation here in Jefferson County.
And are you the supervising officer for Brandon Julius Bell?
Yes.
And do you see Mr. Bell to your left in the wheelchair?
Yes.
Ms. Lopez is identified as the defendant.
The record will so reflect.
As a condition of his probation that was granted by this court back in April of this year, 2025, was he given certain terms and conditions that all probationers are to follow?
Yes.
And specifically, you've had an opportunity to review the motion to revoke that was filed back in July.
Yes.
In account number 1, it alleges that he failed to immediately report to you his or her contact information in violation of condition. Can you explain that to us more?
There were multiple instances throughout the time that he was reporting where I would attempt to call the number he had provided at a previous office visit and would not be able to reach him. So then I would have to then search through his associates to find someone else who would answer, who would then say, we'll let him know you called. And so it's standard in our court orders that they are supposed to keep their contact information updated due to the fact that most of the time I cannot give out certain information to other people due to confidentiality.
So it's obviously very important that you're able to reach him and advise him of the conditions of his probation center.
Yes, we need updated phone numbers, addresses, things like that, so that we can specifically talk to the defendant.
And he pled true to additional allegations, including providing some dirty UA specimens being out past curfew. Was he ordered by the court to provide all records and documentations as required by you to you as his officer?
Yes.
And did he do that?
Yes, whenever it applied in regards to like spindle top, yes, those type things. I haven't had any kind of paperwork in regards to the settlement that Mr. Burbank has referenced, but I also recognize that may be a recent thing, and so that may not be applicable yet, but otherwise, yes.
So some things you're able to verify, but yet others you are not, which is why you felt it important to include English.
Correct.
And additionally, in allegation number 8, did he admit to you the adulteration of his UA analysis on or about June 30th of 2025?
Yes, when he submitted that urine analysis that date, it was clear in the cup, and I did make a note of that in my chrono. It should be noted that even if someone is extremely hydrated, their urine is not crystal clear. And so when I specifically asked him in the offices at that date, did you do something to make it be negative? He said yes. And so while the drug test reflects negative, he admitted in the office visit that he had taken something, drank something to adulterate his urine.
And in fact, you and I have had a lengthy conversation in the past about his use or suspected use of K2 synthetic marijuana, which led to possible negative UAs when in fact he would be positive just due to the nature of that synthetic.
Yes, Ms. Strother, our UA tech, has explained to me that K2 is a difficult drug to drug test for because much like the flu, there are multiple strands of K2 drugs out there, and our drug test can only specifically test for one type. And so if he had not used that specific type, it would test negative. And so the incident reports that I received through Beaumont PD indicated that the effects that they were seeing in their reports indicated synthetic marijuana use.
And that information is also reflected in your update to the court, correct?
Correct.
With respect to how his behavior appeared to be altered, involving odd hours, showing up at odd places, attempting to contact the complainant, etc., regardless of whether or not they mutually agree to do so. And I believe your recommendation is very well thought out and very well put in the updated PSI. Do you have anything to add to the report?
I do not at this time.
I have some questions. Mr.
Yes, sir.
Ma'am, did you ever get his records from Springfield?
I believe so, yes.
And was he under medication?
Not during the time of all of this taking place. I know that since he was out on bond. I believe he went to Spindletop as of August 11th, and that was when he began having his medication the way he was supposed to.
In your report, you stated in the first or second paragraph that while the defendant does report as directed, he has made basic efforts towards paying his fees, correct? So he has been reported to you.
Correct.
And then you also started receiving phone calls from the victim. Did you have any dealings with the victim at all? Were you here the last court hearing?
I was.
She didn't act very rational either, did she?
Not often, no.
And do you realize that they are expecting another child?
Yes.
And how many other children do you remember?
I believe they currently have 3 children together. I believe this is the 4th.
If I told you that there was a settlement to Scott Brown in reference to the motor vehicle accident that took his leg, you wouldn't disagree with that?
He told me that at the jail when I did my PSI update.
And he's getting monthly, I guess, settlement checks or quarterly settlement checks, in which the wife does have access to his account.
That I don't have any knowledge of.
You did also receive telephone calls from his mom, correct?
Correct.
And basically she said that he's talking out of his head, he has mental health issues, right?
She did at one time, yes.
She didn't know, well, has to be between April and now, right?
Yes.
That's what put on.
Specifically whenever he was out on bond.
Okay. He did appear to be kind of delusional state, correct?
Yes.
Unable to remember reference to taking medications or injecting, so he was on some type of medication, correct?
Correct.
Okay. And that one of his problems is that he has to learn how to remain on his medications in order, from Spindletop, in order to, I guess, try to live life normally, correct?
Correct.
Nothing further.
Anything else, Ms. Malfino? I don't know yet what I'm going to do, but is there any reason based on the injury that Mr. Bell could not go to special needs safety? Is that something that would prevent him from going?
I do not believe so.
You don't think so? You don't think so?
I think there are people that have gone to Spindletop that are
Sure.
in wheelchairs and things of that nature.
Yeah.
I say Spindletop, I'm sorry, safety.
Yeah.
So I think he would still be able to go. I think it would be under special needs.
Right, that's what I would,
Yeah.
if that were an option, it would be special needs because that would address both
That
of the.
addresses mental health also, Jeff.
Yeah, that's what it's for. I mean, and here's the thing. I think a lot of the mental health is because you're using synthetic marijuana. I mean, that's gonna, so.
Judge, I think you have a lot of information before you enter your decision. I do think it was important, and I didn't want to hide behind the fact that we have had the issues with the complainant and she did come and testify.
And that's the only thing that's keeping me from doing probably what needs to happen.
But I don't have an interim update with respect to her.
Have you heard anything?
I have not heard anything since all of this happened. The reality is she's called me multiple times and complained and said that Brandon's here and she wants him gone. But Ms. Lopez, please don't send him to jail. She is very back and forth about it. My largest concern, Your Honor, is that the officer
offense that the defendant is on probation for is extreme. And my biggest issue in truth is the fact that Mr. Bell does not take any responsibility for any of it at all.
I don't disagree.
Can I just have one question, Jason? Did his accident happen after
When did your accident happen?
November 4th of last year? Of last year.
So all this has happened since he's been on
No, but
probation.
was this
Prior.
before- was that
His
prior to
accident
his
was
accident?
prior to when he was placed on probation.
Right.
No, but how about the incident itself?
Oh, the underlying offense?
Yeah.
April of last year. So the underlying offense was prior
To his
to the injury, but the injury was prior to probation, where he's still, I mean, regardless of you can still do things to injure someone, to harass someone, to put someone in fear with or without a leg. And that's what he's done. That's what you've done. Still make babies with her. I mean, I don't know. I mean, that she was pregnant. The whole point of this is you beat the crap out of her when she was pregnant, and now
Third child.
and now we've got the fourth.
Correct. Did you want me to do a bailiff's call for her and see if for some reason she showed up today? And
Sure.
Court needs to speak with her. Adriana Bell.
Can we do a call for,
Adriana Bell.
I don't know if that's gonna help either, though. We've done that before.
And I don't know if this is a situation where it's the court needs to protect somebody from himself.
Mhm.
Do you want to reset it so I can?
I don't think it's gonna matter. I mean, she's been here before. I've ordered,
No response.
I think I have her mother's here.
but they had it, there was a no contact, and now we have another baby. So obviously there was contact.
Can I address that from what I found out, Judge?
I don't need Snickers from the gallery.
I'm not calling them as witnesses. Every time they got mad at each other is when she got on the phone.
But she got on the phone, but that's him blaming. He beat her. You admitted to beating her. So she's probably scared when he gets mad. And then it gets okay, and then it gets mad. And he doesn't know how to get mad without beating the crap out of her.
I didn't get that indication, Judge. She's been to my office every other day. She's called. I mean, it's really,
I'm not in disagreement that Ms. Bell is also the problem, but my biggest concern here is their children.
separation.
Yeah,
I don't care if they stay together or not, admittedly and frankly.
Yeah.
I'm more concerned about the children involved in this case because of the violence that they're being subjected to. Whether or not the two of these adults can reconcile is between them, but there are children involved that I am extremely concerned about.
I agree. All right, here's what I'm gonna do. Mr. Bell, I don't feel like I have any other choice at this point but to protect your children and to protect your, I don't know if y'all are married, girlfriend, wife, mother of your children from you. I understand the mental health issues. From what I can tell, most of those are self-induced because you were using K2.
There haven't been an incident since I've been on probation.
That's not true.
I haven't had no abuse cases. I've been on probation.
Okay, so you haven't abused her, but you weren't even supposed to be around her. I gave you don't talk over me, because y'all I told you when I put you on probation that she cannot give you permission to violate my order.
Yes, ma'am.
She can't say, it's okay, come on over.
She came to my house. I was staying in the house. She wasn't staying there.
Lock the door, kick her out. You're the one that's going to go to
She
prison.
said that she called the laws to kick me out, and you said it still was an issue. She called the laws to kick me out. My mama came and got me, and I've been staying with my mama. I ain't been around her. She been calling the laws on me every time she come to my house. I paid $100,000 cash.
Why are you still having sex with her and having babies?
That's early on.
Early on when? We've only been doing this for 6 months. You've had 6 months, and all this has happened in 6 months on probation.
It happened 3 months. Cause she finna have a baby next week. 3 months before I was on probation.
So what if she shows up at your mom's house?
She not gonna show up over there. She know her and my mama don't get along.
Probably for good reason.
I would represent to the court that there is a problem there, Judge, because even when we talked about possibly with him seeing the kids without her at mom's, and that wasn't a possibility. It's something between her and the mom, his mom. And I know his mom, his brother has gotten in trouble. She has a very stable job at a bank. She's very straight-laced. His brother was the one in the West End that was burglarizing cars, and the owner stopped him and shot him about 8 times on the road and left him there. But she is very straight-laced, and she just couldn't get off of work this morning because of the bank.
So,
But he needs something, Judge. I mean,
well, but we tried to give it to him.
well, I'm talking about.
I have money now to pay for my battery class too. I have money to pay for my battery class and pay off my probation.
I'm not as worried about you paying off things as I am you having continued contact with her.
I'm not gonna be in contact with her anymore.
Is there a way, Judge, to put him on a GPS and reset this for 60 days?
No, I'm going to make my decision today because I'm absolutely, if I leave him on probation, he's going to safety, period. So we're not going to get out and see how we do and take that chance without having some kind of treatment up front. I don't know. Y'all hold on a second. Just don't take them far. Mr. Malfino, and sorry again, you're Brandon Bell. And so just to get us back where we need to be, everybody's reviewed pre-sentence report, made argument. I want to go back just one more time and see. I know, Mr. Burbank, you're asking that I continue Mr. Bell on probation. Ms. With treatment. I know Ms. Lopez has made her position very clear. Ms. Malfino, what is the state's position?
Judge, I certainly have ultimate respect for Ms. Lopez's position. She knows the defendant and what she's been dealing with a lot better, probably has a slightly different perspective on the kid other than what I do, so I certainly defer to her opinion. I also at the same time agree that probably the safety special needs to address that synthetic marijuana issue may be relevant. Has he had that opportunity in the past with some other charges? Yes, very well so.
So what?
Revocation may be appropriate, Judge, based on the underlying offense itself. If it is not, of course, we would be of the opinion that if he goes to that and violates zero tolerance in any way, shape, or form, we ask for that.
Okay, I'm just reminding myself also, so what I did not do previously was go through and take a look at that old pre-sentence report, which has the criminal history, which includes
several sentences in prison.
Already been to prison, given an opportunity on probation in 2020, which is not long ago, 5 years ago, revoked and sent to prison for 2 theft cases. One was a TDC case given 3 years. And so pretty much gets off parole barely and commits this offense, gets the opportunity at probation, and we're where we are now.
I think it does have an extensive juvenile history. You will see a misdemeanor as well. And again, that's
Yes.
why I wanted to let the court know that. An underlying probation offer was made with the issues with Miss Adriana Bell that the court is obviously aware of by this point.
Okay. I am looking back at history, juvenile history, going back to 2013. Assaults, violation of court orders that look like it should have ended up in Texas Youth Commission. For some reason, they kept putting you on probation all the way until 2018, when you apparently become an adult. Then you start getting felonies and misdemeanors, get probations on all of those. Those are revoked. You beat the mother of your child while she's pregnant. You get a 5-year deferred probation, and you don't take advantage of that probation. I feel like at this time, what Ms. Lopez said is absolutely correct. You are a danger to your children, you're a danger to the mother of your children, and in my opinion, you're a danger, a menace to our county, and have been since 2013.
Just one thing. Do you know when his mental health was discovered?
Probably when he started using synthetic marijuana. So at this time, I'm going to find that you entered your plea of true. So you were previously in court, entered pleas of true to counts 2, 3, 4, 6, 7, 9, and 10. And then today, I am going to make a finding of true to counts 1 and 8 based on the testimony of Ms. Lopez. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And I'm going to hand you, and y'all need to sign this, trial court certification that shows this was not an agreement. There are some rights to appeal. You can talk to Mr. Burbank about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you. Hang on. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. You need to sign that, and then I'll get you a copy of it, and then you can go back with the bailiff. I do think that's fair, and hang on to Mr. Bell. I can go up to 20 years today. Talk to Mr. Burbank about that.
Is it?